pressure, my lord, to conduct. But there is a stay, my lord, in operation.
Here for the
State
department.
State department.
Okay.
It will be on next Tuesday, my lord.
Next Wednesday.
Wednesday. Oh, please. Thank you, Lord. Item number 10, you filed one affidavit. They may kindly be called. Yes.
Yes, it's a lot of recommendation for listing of the matter for admission. The matter pertaining to non-payment of enhanced compensation and duress made to the petitioner by the Deputy Commissioner,
Matter of which year?
which is 2022,
22. Okay. We'll have next Friday.
next Friday.
Hmm.
Lordship, kindly matter will be taken up 21 March.
Not like that. 21st March is a hearing day.
Lordship,
Thursday.
28.
2/8. Not on a hearing day. We'll have it on 27th then. 27th.
Coronia preparing this matter.
Where is he?
That matter will be taken after contact and ballot. Granted, Advocate General is also appearing by it. Also is coming back.
Motion matter, it will be called first. Okay, after a while. Item 14, motion D. Bora. Mr. Chutia, what is this?
Petitioner filed, my lord, regarding, my lord, is
Mr.
Wait for a while. Yes. Sit
Lord,
down.
let him
Sit
start.
down. Yes. What is this?
my lord, petitioner earlier filed a writ petition, my lord, for demarcation of the land, and there is a ownership dispute between the three parties, my lord. The petitioner has not annexed any document that he is the owner of the land. One suit is pending in Calcutta. The person, the Hanuman Tea Street, my lord, the petitioner claimed that he purchased the tea garden from Hanuman Tea Street, my lord, and they have filed a suit in the Calcutta, my lord. So, my lord, mutation proceeding is going on, my lord, and we asked him to file the original documents. The petitioner did not file the original documents, seal date, my lord. So the mutation case is
So
pending.
what is the relief is he seeking here?
Here, my lord, there are some persons, my lord, encroach the land, my lord. If it is his patta land, my lord, encroachment for eviction of the encroachers, he filed the present petition. Present petition is filed. This petition is filed for eviction of the encroachers, my lord. If the periodic patta land is there, my lord, periodic patta is there, not in the name of the petitioner, my lord. It is in the name of the original owner. And thereafter, it was purchased by the Hanuman Tea Estate, and there was a proceeding in the, my lord, debt recovery tribunal.
So far as prayer number 5 is concerned, that would be subject to the outcome of the suit, I think.
My lord, that is the, my lord,
The
in
process to expedite the process of mutation.
my lord,
If there is a suit pending,
my lord.
unless the dispute is resolved.
My lord, my lord. Now, suit is filed, my lord, Hanuman Tea Estate, implementing him as a party, my lord, and he has not annexed any document of that particular case. Why the mutation case is pending? And we have issued notice to him to submit the original document on the basis of which he claimed the mutation, my lord, title. That document has not yet been furnished, my lord, by the petitioner. And now some persons encroach his land, my lord. So he filed this petition for promulgate of 144 CRPC like that, my lord. That is, that prayer is, my lord, to promulgate the 144.
Now the basic issue is regarding prayer number 4, Lord, to stop the illegal encroachment, Lord. If that is done, Lordship, then subsequently, Lordship, on the basis of document,
Enforcement, these are factual matters, don't you think?
thing is that, Lordship,
You take instructions.
It is from the periodic patta land, my lord, whether the Karbi Anglong Autonomous Council.
No, these are essentially allegations touching the factual aspect
My
that
lord.
somebody has encroached.
My lord.
somebody has on the regarding Lordship enforcement, earlier, Lordship, the Joint Secretary Revenue, Lordship, he has written to the that
Okay, we need no issue notice at this stage.
Notice may be go Lordship, and in the meantime, Lordship, the respondent may be instructed Lordship to take appropriate measure to stop the encroachment, Lordship. That's not.
That,
Yeah, we cannot.
that is the final prayer.
No, final, otherwise, Lordship, this petitioner will be responsible because the land will be encroached by the illegal.
If it is
encroachment.
encroached, the encroachment cannot be removed.
That can be removed, but it will take
Then-
prejudice because it will take time, Lordship, because they are going to construct their Lordship illegal.
These are
Contract-
factual assertion.
Lordship,
You-
kindly have a look at page 25. Earlier, Lordship, kindly page 25.
Sorry, not.
Page 25, not
Heard Sri J. Kolita, learned counsel for the petitioner. First of the petitioner claims to be the proprietor of Lahorijan and Nirmal Kumar Tea Estates in the district of Karbi Anglong. First of, though some portion of the land has been acquired for the purpose of construction of a 4-lane highway, comma, taking advantage of such process, comma, the petitioner has alleged that there has been encroachment
Right.
on the aforesaid plot of land, full stop. Petitioner also claims to have filed representations,
Yes.
in spite of which no action has been taken, full stop, para. Sri J. Chutia, learned standing counsel, KAAC, however, submits that no document regarding the ownership of the land in question has been annexed in this petition, full stop. Further, there is a suit pending regarding the ownership of the land in question, which has been filed before the competent court at Kolkata,
It's not
in
been
which-
mentioned.
in which the petitioner is one of the defendants. Full stop, para. Be that as it may, let notice be issued, returnable by 6 weeks.
Lordship may fix the date, Lordship.
Just a minute, returnable by 6 weeks. Chief Secretary, who, yes, Ms.
I'm
M.
for 2
Burma,
and 3.
1, J. Chutia, KAC, Standing Counsel, KAC, 2, Revenue, the 2, 3. 2, 3, who is for 2, 3, Deputy Commissioner, Madam?
5, 6, and 7.
You are for 1, 5, 6, and 7. M. Burman, 1, 5, 6, and 7. And J. Chutia for 2 and 3. NHIDCL, Architectural NHIDCL. So let extra copies of the writ petition be served upon the learned counsel for respondents by tomorrow, within 2 days, full stop, para. Pendency of this petition shall not be a bar for the authorities to consider the representations
Sir.
filed by the
In
petition.
pursuance of Lordship, first order of the, in pursuance of Lordship order that.
No, yes, next.
Apply.
Yes, Mr. Sorania, where are you?
I'm bit late, Lordship, due to some problem, my lord.
Yes, what is this?
May I please, Lordship. My lord, matter relates to my lord, social status of a member of parliament, my lord, sitting member of parliament of Pokrajur constituency, my lord, who belongs to Bodo community on the basis of a complaint filed by a citizen of the my lord constituency. The SLC, my lord, is opinion that the petition is not belong to Bodo community, my lord. That
Where
is-
is the opinion?
opinion is, my lord, annexure 27, page 111, my lord, 111,
111.
my lord.
This committee has been formed as per Madhuri Patil's.
Madhuri Patil, but we have challenged the committee also, my lord. That is not as per the guideline of the Madhuri Patil, my lord. That has been under challenge, the committee itself also, my lord. And the vigilance also, my lord, which will constitute as per the OM issued by the government of Assam, my lord.
111 is the impugned order, is 12-1. 12-1,
My lord, may I read, my lord?
yes. Please,
My lord. Where a representation dated 16/6/19 was submitted to the state level scrutiny committee by Janaklal Bosumotari, President of Sonso, for cancellation of the STP certificate issued by to Nobokumar Koronia by the All Assam Tribal Sangha Tamulpur Sangha, Tamulpur unit, contravened by SDO Civil Tamulpur issued by non-dated Choncho. Whereas on receipt of the aforementioned reference, the state level scrutiny committee initiated necessary proceeding to verify the caste ST status of the Novokumar Horonia. The committee requested the Director of Tribal Affairs, Plain Assam, as well Director of WBT in Assam, file letter dated 11/7/19 to inquiry into the caste certificate of the Novokumar Horonia, Honorable MP IP HPC through Vigilance Committee and to submit the inquiry report. Whereas the Vigilance Committee made a request to the Superintendent of Police CID to inquire the submit a report to the caste status of the Sri Novokumar Horonia so and so. The Office of the Superintendent of Police CID made a field inquiry of the caste status of the Novokumar Horonia and submitted report filed letter dated 25/10/2020. It should have been, I think, 19. Whereas Deputy Secretary Baska was also requested to submit a on on caste status of Novokumar Horonia, taking into account the documents relating with his land and legacy data, filed letter dated Iman, and Deputy Commissioner Baska Mosulpur submitted a report, filed letter dated Iman 6/11/2019. Whereas on receipt of the said first report from the Office of the Superintendent of Police, the Director of Tribal Affairs issued the so-called notice to the Novokumar Horonia, notice dated Iman Frenso 11/3/2019. So, my lord, here on the so-called notice has been issued on the basis of first report. There are two reports. Where the Novokumar Horonia white petition dated 4/8/2022 and 18/6/2020 sought extension of time to submit his replies, and letters he submitted his replies on 31/8/2022. His so-called notice dated of the Director WBT and BC Assam. Whereas Janaklal Bosumute submitted his replies to the so-called notice issued by the Director of Tribal Affairs, Plain as well WBT Vision 21/9/2021. That has been not supplied to me, my lord, that reply. Whereas the CID in the meantime submitted their second report, filed CID so 4/3/2002.
Yes.
But so-called notice was issued only on the basis of first report. This is a second report. What is the occasion, my lord, to issuing a second report, my lord, second inquiry? Whereas on receipt of the second report from the CID, Assam Vigilance Committee held its meeting on 14/9/2020 and decided to refer the case of the State Level Scrutiny Committee dated 18/9/2020. Whereas hearing of the State Level Scrutiny Committee was held on 11/11/2020. The committee heard Novokumar Horonia in person and produced his stand on the reply dated 30/8/2020 to so-called notice submitted to the Director WBT and BC Assam. Whereas hearing of the State Level Scrutiny Committee was held on 4/12/2020, wherein the committee heard Janaklal Bosumute in person, Sri Janaklal Bosumute submitted another written statement on that day, which has been produced by the committee. Whereas the Advocate General Assam was requested to offer view in connection with the High Court case WPC 2580 of 2014, wherein the caste certificate of the Sri Novokumar Horonia is under challenge by endorsement dated 28/2/2020 in the file long so. However, Advocate General opined that his endorsement dated so. Yes, I am of the considered opinion that as the stage of the proceeding is proceeding, it would not be appropriate for me to offer any view or opinion as the same may influence the decision of the scrutiny committee, which has its own authority and power to decide the issue in hand on merit on the basis of the material and evidence placed before it during the course of hearing by following due procedure in law. Whereas the committee referred to the comprehensive procedure for the issuance of social status certificate and procedure for scrutinizing the genuineness of or falsity of social status certificate has been laid down by the Supreme Court in case of Madhuri Patil, wherein it is held that each directorate should constitute a vigilance cell consisting of senior superintendent of police in overall in charge and such member police inspector to investigate into the social claim. The inspector would go to the local place of residence and original place from which the candidate hails and usually resides, or case of migration of the town or city, the place from which he originally hailed from. The vigilance officer should personally verify and collect all the facts of the social status claimed by the candidate or the parents or guardians, as the case may be. He should also examine the school record, birth registration, if any. He should also examine the parents, guardians, and the candidate in relation to their caste, etc., or such other person who have knowledge in the social status of the candidate, and then submit a report to the director together with all the particulars as included in the pro forma. Here is no pro forma, my lord. They have not issued any pro forma. How to make the report? In a particular of the scheduled tribe relating to their peculiar anthropological and anthological traits, deity, ritual, custom, mode of marriage, death ceremonies, method of burial of dead bodies, etc., by the caste or tribes or tribal communities concerned, etc. Whereas the SLC examined in detail finding of the Vigilance Committee, which were as follows. 1. The STP certificate was issued in the name of Navakumar Soronia, son of late Lakhikanta Soronia, address Digli Park, Post Office, PS Tamalpur District, Baska District, as Bodo Kosari on 12/10/2021, signed by the Vice President, All Assam Travel Sangha, Tamalpur District Unit, and Tata signed by the SDO Civil Tamalpur Subdivision on 19/10/2021. 11. 2. Record obtained during the course of inquiry reveals that parents and grandparents of the Navakumar Soronia, son of Lakhikanta Soronia, use surname title such as Sorukos, Das Deka, which are not listed under the Porokosari. 3. Srimati Dipanita Soronia, sister
We
of
have
the
read this. We have read the.
My lord. My lord, my lord, the ground of challenge is, my lord, the procedure, my lord. The constitution of, my lord, the SLC, my lord, where because states have not enacted any law, my lord, in regard this. Still, my lord, the Matri Patil list, my lord, direction is prevail, my lord. So is there no the spirit of the Matri Patil case, my lord, as directed in paragraph 13, my lord, 1 to 15, my lord, subclose, are required to be followed, my lord, in letter and spirit, my lord. So while constitution, my lord, state level scrutiny committee initially, my lord, let's come to page 5, annexure 5, page 48. This is a committee, my lord, prior, my lord, who has first directed to inquire to matter, my lord. Here, my lord, the
Page
page 48, my lord.
48.
48.
Yes.
Here, my lord, as per the Matri Patil case direction, my lord, at paragraph close 4, my lord. There be, my lord, the committee, my lord, by the officer, subsequently 1997, my lord, in a review petition, it became a 5, my lord. So here is a 6, my lord. So 6, my lord, because as per direction of the Matri Patil, both 97 and 94, it should be 5 members. So here is 6 members, my lord. So when there is a time, my lord, who will balance, my lord? Suppose there is a difference of opinion, my lord. Is supposed to go for vote for any, my lord, kind of, my lord, opinion is to be done, my lord. Because as part is the 3 members is a majority, my lord. If 2 is, my lord, in deciding side, my lord. So here is 6. Secondly, my lord, the superintendent of police, my lord. Others he can be a member. Others he cannot be a member because he is the heading the, my lord, inquiry committee. He is heading the inquiry committee. That means, my lord, and otherwise, so this the inquiry vigilance is to be led by the senior deputy superintendent of police as per Matri Patil by officer. So they have formed a, my lord, committee which SP also included, my lord. Then they have this member also included. Actually, in part as per Matri Patil, only senior deputy superintendent of police of the and the 2 officer is to be form a vigilance committee.
This person at serial number 5, he is not junior, he is not lower in grade than the officer prescribed.
No, I'm not on my lord, that my lord, the committee,
If
my
you
lord,
say that Madhuri Patil strictly, if he's strictly followed,
my lord.
then senior deputy superintendent of police should be there. Here we have seen that
That is the vigilance committee, my lord. Here, so he is in the my lord vigilance committee also. At the same time, he is the my lord state level scrutiny committee also. That his report, he has to scrutinize, my lord. What he said, my lord, in the report, as a vigilance committee, my lord, vigilance cell, my lord, that his decision will be prevailed because he has, under his supervision,
these are
encouraged and protected.
the members per se are not personally attached. These are by post.
By nomenclature, my lord, even my lord, by nomenclature, they have been, by nomenclature also, my lord, not by name.
Yes.
But in case of the my lord officer, they are by name, my lord. So this is one my lord of the my lord. They have not followed, my lord, as per Madhuri Patil 4, my lord.
Let
I
us
will
see
provide a copy of the Madhuri Patil.
let us
my
see Madhuri Patil.
lord.
Citation, please.
My lord, 1994 6 SCC 241.
Paragraph
My lord, paragraph 3, my lord, 13, my lord,
1-3.
1-3, my lord. Two? Yes. Good. Okay. My lord, page 254, my lord.
Yes.
Then paragraph 13, my lord.
Hmm.
There is a guideline, my lord. May I read from the paragraph 13, my lord?
You read the guidelines.
My lord. My lord. It is for that purpose, it is necessary to streamline the procedure for the issuance of social status certificate, their scrutiny and their approval, which may be as follows. 1, 2, 3 is not relevant, my lord. When is met applicant, my lord, that is that procedure.
Hmm.
So, my lord, let's may come to 4, my lord.
Hmm.
All state governments shall constitute a committee of 3 officers,
Hmm.
namely an additional or joint secretary or any officer higher in rank of the director of department concerned. That is must be above the director, mind. The director of social welfare,
Hmm.
oblique tribal welfare, backward classes, welfare, as the case may be. Because in case of ST is different,
Yes,
OBC
yes.
is different, SC is different, madam.
Hmm.
So that's why here 3, madam. Third, in case of the scheduled caste, another officer who has intimate knowledge in the verification and issuance of social status certificate. This is in case of SC, madam. Now next is for ST. In case of scheduled tribe, the research officer who has intimate knowledge in identifying the tribal communities, part or group of the tribal communities. So the number 3 officer is not in the minor SLC, minor that level scrutiny committee.
Right.
Research officer, minor. S is related to my lord. Let's come to the annexure 5, my lord.
Who is this at serial number 6?
Serial number 6,
Joint Director?
joining the Assam Institute of Research, Training and Scheduled Caste. That is the one institute who do research. So here, my lord, joint director, maybe my lord, he is from the research institute. He may not be a research officer, my lord.
No, he's the
He may
joint.
not have intimate. No, my lord, the ACS officers are holding those posts, my lord. So this must be a research officer, my lord. Who
No,
is
if-
the intimate
if
knowledge
he's-
of scheduled craft?
No, if he is the joint director of an organization indulging in research, if you are making up an allegation that he will not fit into the scheme of things, then you have to have specific pleadings.
I have,
Who
my
was
lord.
this officer?
My lord.
Who was this officer?
The my lord joint director, we applied for the my lord the name of this constituent committee members, my lord. The authority, my lord, failed to give information that their names are not
That
available.
is a different subject aspect we'll look into, but if you make an allegation that
No.
this officer may not have intimate knowledge,
That should have been put that the joint director AIG, come research officer. The research officer, he
No,
must
see,
be a research,
research
that
officer-
should be my lord.
Research officer and joint director is much above a research officer.
No, my lord, in joint director, in case of this are held by the SCS officer, my lord.
Where are your pleadings that this officer does not have any intimate knowledge? These are vague allegations, speculations.
My lord, because they are, while making a
And
member, my lord,
are you challenging the constitution of 2018 for the first time now? Only because the finding has gone against you.
my
If
lord,
the finding would have gone in your favor, would you have challenged the constitution of the committee?
no, my lord, that
Or
time,
when was the first opportunity, first time when you had raised an issue regarding the validity of the committee?
my lord, even then, my lord, to justify that he's a research officer or whosoever, my lord, even there is no minutes, my lord. Not at a single meeting, there is a minutes. 2 minutes is there, he's not related, my lord. Not a minutes, my lord. Even then, my lord, when impugned order is passed, when the my lord petitioner appeared, the private respondent said to be appeared, there is no minutes, my lord. How we drawn of this person impugned speaking order, so-called speaking order, my lord, without minute, where they are, what they have discussed, my lord. We applied for the minutes also. They denied to give, but there is no records of minutes.
Now, who are these officers who have signed as at page 115?
My lord, we asked for provide the names of those officers, my lord. They failed to give, my lord.
We'll have see, Mr. Sarania, examining this matter is not a difficult issue at all. We'll examine.
My lord,
You are also praying for an interim order.
my lord,
That is the reason we are trying to
my lord, my lord,
elucidate from you what are the grounds of challenge,
My
whether you can make out a prima facie case.
my lord.
This speaking order has cited reasons.
My lord.
Reasons we have to examine the reasons from the perspective of its lawfulness. Correctness is a different aspect altogether. If the procedure has been followed, our jurisdiction would be a very limited one.
My lord,
But if you can make out that it is not done lawfully,
my lord,
the decision, our final outcome may be erroneous. That's a different aspect
my lord,
altogether.
my lord.
We are on the lawfulness of the decision, not on
Right.
the soundness, that is the settled law, jurisdiction.
My lord.
So if to assail this speaking order,
Right.
you have to make out a case that the relevant factors have not been taken into
My lord,
consideration.
lordship,
Irrelevant factors have been taken into consideration.
Right.
There is no application of mind, or it has been done mala fide. These
Right.
are the basic points where you can urge you can formulate your
my lord, then lordship may come to page 28, my lord. These
Two-
grounds I have taken.
to
my lord.
8.
28.
Yes. Yes.
Lordship, first, my lord, first ground, para 36.
To 8. Yes, please.
Page 28, para 36.
Yes, please.
My lord, the petitioner back to state that these are the gross violation of the procedure laid by the Supreme Court in Madhuri Patil's case and the procedure as directed by the office memorandum dated 11/5/2018. Therefore, the legality and validity of the impugned so-called speaking order dated so and so by the SLC is challenged on the following amongst other ground, my lord. First, my lord,
No, this you have already urged. We have heard you on these grounds that the Supreme Court's
there is more, my lord. This is only three, my lord.
no, those which you have not urged, you can point out those grounds. First, 3.
First of my lord,
Residence Committee, all 5, 1, 2, 3, 4, 5, you have already urged.
my lord, that there is a first report, my lord. That first report is in my favor. So without my
Where is
lord,
the first report?
first report, my lord, I am coming, my lord. Lordship may come to page 63. 63, my lord.
63.
My lord. That will be in exercise 12, my lord.
Just a minute.
Point number 2, my lord.
No, this is not by the committee.
My lord, if my lord, the vigilance cell submit a report, my lord, the director has to take a decision. So director, where he has taken a decision, the director that this is not proper, I'll go for the second inquiry.
No, see, ultimately, the call has to be taken by a duly constituted committee as directed by the Honorable Supreme Court. These are materials which the committee can consider while coming to a finding.
No, my lord,
You
before,
say that there is one document
my lord,
which goes in your favor and this perhaps was not taken into proper perspective by the committee. That can be one of your arguments. But this is not the final report. Report is that of the committee.
my lord, lordship may come to then 5 of the, my lord, Matripatil's direction, my lord.
Yes, please. This inquiry is by whom at page 63, Mr. Sarania?
My lord.
By
This is by the, my lord, one Jaduram Malakar, who is the one of the member of the, my lord, vigilance cell.
report by Inspector of Police.
Inspector
CID.
of CID,
Okay,
my lord. So he, the, my lord, the committee, my lord, that committee has been constituted, my lord, on 6/6. Annexure, my lord, 7, my lord. This is the committee, my lord. That has been also under cell. This is the, my lord, vigilance cell.
Let us have a cursory glance at page 63. 63, that CID report.
My lord. My lord. Lordship may come to point number 2, my lord.
Just a minute. Yes, point number 2.
For verification of caste certificate of Novokumar Hoinia, MP Kokrajar HPC, son of late Lakhikanto Soronia of Digili Par, PS Tamulpur District Basa, I have visited the given address, examined the person noted and other prominent persons of that locality, and found that this said person belonged to Soronia Kosari community, which is under the purview of STP category. In this regard, I collected the copy of the letter issued by the government of Assam Department of Welfare, Parent Tribe and Backward Classes, Dispur Guwahati referred letter to so 15 June 2018, addressed to all the Deputy Commissioner of District of all Assam, SDO of Assam, directing to issue STP certificate Soronia Kosari community as the Kosari scheduled tribe in Assam. For ready reference, I am enclosing photocopy of the certificate along with the gov letter as ready reference, which is Annexure Annex B. Now last para. In course of inquiry, it is found that there are 3 persons, including my the petitioner. It is found that the complaint lodged by the civilian, namely Miss Fatima Khatun, Janaklal Bosumare, in the case matter, Janaklal Bosumare, in case of this petitioner, and Karisma Sarkar is not genuine. The OBC
Incumbents.
the incumbents noted belong to OBC, STP, and OBC respective. This is the first report, my lord. So it is according to the direction of the, my lord, being a, my lord, vigilance committee, he submitted a first report. So to negate the first report, they to have a decision, my lord, pass an order, my lord. Then they can go for second report. And my lord, I am, my lord, the direction of the 5 in material case, my lord. No, 550. 5 to Lordship may come to guide, my lord, direction 5 of the material case.
Just a minute. Yes,
My lord. The direction 5 of the material, my lord.
yes, just a minute. 5. Page.
Page 255.
Yes,
my lord, merit.
please.
Each directorate, that means there are three directorates, my lord, SC, ST, and OBC.
Hmm.
So each directorate should constitute a vigilance cell consisting of senior superintendent of police in overall in charge. And such member of police inspector to investigate into social status claim. The inspector would go to the local press. These are the, my lord, same repeated, my lord, these are the how to move, my lord. Now let's make count to 7, my lord, direction 7, my lord.
Hmm. Yes,
So, my lord, the vigilance cell is headed by the senior superintendent of police and other police officer. Here they have nominated 2 inspectors. 7, my lord. In case the report in favor of candidate,
yes.
7,
Hmm.
found to be genuine and true, no further action need not be taken except when the report of the particular event are produced, procured, or fraud to be false,
Found to be false.
found to be false or fraudulently obtained, and in the latter event, the same procedure as expressed in the para 6 to be followed. So when the report is in my favor, they have to come draw an opinion. This is false, fraudulently procured, whatever it is, my lord. Those are missing, my lord. Then why they have gone for second inquiry, my lord? If it is found to be, my lord, procured, found to be false, fraudulently obtained, the directors could have from an opinion that it is not a correct report, we will go for the second report. Where is the opinion, my lord? There is no opinion, they have not done, my lord.
Unless the procedure, the particulars are found to be false or fraudulent. That's-
But the input order, my lord, said that they have issued me the show cause on the basis of the first report, my lord. So first report is in favor of me. Second report, they are not concerned. I also do not know. I know later on. But they have not informed that it is go. I don't found that the inquiry is not genuine. We go for further inquiry.
You're trying to contend that as per guideline 7,
My lord.
if the report is in favor of the person whose caste status, social status is
Found to be genuine.
is put under question, if the report is found to be in favor of such
No
person,
further inquiry.
unless the particulars are found to be false or
Procured.
fraudulent,
Fraudulent.
then there is no requirement of further proceeding with the matter.
No, my lord. So in that case, they have not done anything, my lord. And second, and even in the impugned, my lord, order, so cause notice has been issued on the basis of first report. So how, my lord, they have, this is not a reasonable conclusion, my lord. You are,
Let us see this cause.
my lord. My lord,
You-
the
you-
impugned order, my lord.
You are saying 23/10/2019 is the first report
My lord,
at page 63.
my lord, this is the 23/10/19 is the first report.
First, page 63.
63. My lord, this second report is my
Where
lord,
is the show cause?
my lord. So cause, my lord, it is 83. My lord, 83, my lord.
83.
Annexure 81. And here also, my lord,
Just a second. 80?
82, my lord, 82, 82, Annexure 18.
Okay. Where is the reference to the first report?
This is the, my lord, focus notice.
Where is the reference to the first report?
My lord, is the impugned order, my lord. They have stated that focus notice has been issued. Here they have not mentioned, but in the impugned order. Impugned order, my lord, logic come, my lord, second page, my lord. Page 112. Page 112, first paragraph.
Yes.
Whereas, my lordship,
Yes.
whereas on receipt of the first report from OO Superintendent, Officer Superintendent, CIDT, Director Tribal Affairs issued so cause notice to Navakumar Sorina, Vice notice dated Iman, my lord.
Hmm.
So on the basis of first report, where the first report goes against me, my
Now,
lord.
where is the first report reference? 23/10/2019. Mrs. Sarani?
My lord. My lord, my lord, oh, my lord, this is the height notice dated one. This is a show cause, my lord.
No, no, you say that the so-called notice has been issued in terms of the first report of 23/10/2019.
My lord.
And in otherwise also your submission will not be correct because this so-called is of March 2019. Report is of
No, my
October,
lord. No, my lord. Notification number this is.
not notification
No,
number.
no, my lord. Here, my lord, there, this is 20, my lord, supposed to be 20, my lord. They're putting wrongly that, my lord.
Which date wrongly?
Even on
First
somewhere, they're
report.
putting 29, my lord. 29 will not
First
yet
that
reach,
issued
my lord.
so-called Office of the Superintendent of Police.
Lordship may come to the, my lord, date so cause notice, same notification number, my lord. Only here, communication, same number, my lord. Here is 20, my lord. Annexure 18, my lord. Page 82.
Page?
Page 82, my lord. This is the so cause notice.
Yes, we have seen so-called notice.
Yes, my lord. In the top, my lord, notification number, last is 48, my lord. 11/3/2020. Here, my lord, they have putting 19, my lord. That is the difficulty. Otherwise, same note, my lord. It should have been 20 in place of 19.
11.
Just mechanically pass, my lord. Even they are not aware of the proper date and year, my lord.
Notice. First report.
Oh.
Okay.
Yeah, please.
4-2. 4-2. This show cause notice
My lord.
at page 82.
My lord.
If you read the show cause notice, uh, please read it. It will be
My lord.
relevant.
My lord.
Whereas a complaint petition was received by so and so against the scheduled caste certificate issued to you based on your claim that you belong to ST community,
My lord.
Boro Kosari.
My lord.
Whereas vigilance cell constituted by the director so and so in person so and so has entrusted Joduram Malakar, okay, same officer,
My
okay,
lord.
inspector for conducting an inquiry as ascertain genuineness. Vigilance officer is instructed so and so. You can skip up the next paragraph, come to the next paragraph. Whereas the vigilance officer Joduram Malakar duly conducted inquiry and submitted his report on 4/2/2020.
My lord. My understand, my lord.
Where is this 4/2/2020?
This is the, my lord, the second report, my lord.
Where page?
My lord. Annexure 17, my lord, page 74.
74.
74. The 4/3/20 is the forwarding of the SP, my lord, to the director. The report is as Annexure 17, page 74.
Just a minute. See, the so-called notice prima facie does not show that there is a reference to the report of 23/10/2019, which you are terming to be the first report.
My lord, that's why,
We'll have to put the question, what was the status of 23/10/2019?
my lord,
When this report was in your favor, where is the requirement to make another inquiry?
my lord,
And was there any consideration for discarding the first report?
my lord. No minutes, my lord. We
But
applied.
show cause notice does not, your contention prima facie does not appear to be correct when you contended that it is on the basis of that report that the show cause notice was issued. Show cause notice talks about something else, 4/2/2020,
My lord,
and but you may be right in contending that in the impugned picking order,
my lord. They are not
There-
right, my lord, because
show cause notice dated. First report. What is this first report?
they are
At
not, my lord.
page 112.
Which is in favor of me,
Okay. Yes. Anything else?
my lord. Secondly, my lord, while passing the impugned order, my lord, only the contention made by the complainant, my lord. That had been, my lord, this issue, my lord, whatever I have filed written statement, even those are not reflected. They have not taken into consideration.
Okay. Interesting case. Yes.
My lord. Secondly, my lord, in the my lord, so cause notice, my lord. They have not referred provided me the, my lord, complaint, my lord. I have stated, my lord, in my second reply, my. Because we did a presumption, my lord, there is another complaint in 2014, my lord. By this respondent number, by private respondent along with two others, my lord. That has been submitted to SDO Tamulpur. SDO Tamulpur forwarded to the DC forwarded to the GOP, my lord. Thereafter, we thought on that basis this inquiry has been conducted. We also replied, my lord, they have never mentioned that in 19, that in 19, my lord, there is a, my lord, is 11/6/19, there is another complaint, my lord. So accordingly, we have filed our written objection, my lord. Then when in the that day 11/11/2020, my lord,
Which you have said you have submitted that copy of the complaint was not furnished to you.
My
Which
lord.
which copy?
that complaint
Which-
lodged by the complainant,
Dated?
dated, my lord, annexure P, I think 3, my lord. Annexure 6, my lord.
Dated?
Dated, my lord, 11/6/19, my lord. They provided me the statement of the vigilance committee, my lord, who was whatever statement recorded. Not the, I was the impression that there is a repetition that has been annexed, my lord, in the repetition in 2014. I thought that on the basis of inquiry has been made. Accordingly, I have replied. Then when 11/11/2020, there is a personal hearing was taken place before the office of the commissioner secretary. Then we come to know about this, my lord. Then I asked to supply, they supplied. Here after, my lord, there is another additional written statement, my lord. Objection from my side, my lord. Stating that has been not supplied. That all these things has been not taken into consideration in the while passing the impugned order. Secondly, my lord, the constitution of impugned, he also under challenge, my lord. Page annexure 20, annexure 26, my lord, page 110, my lord.
110.
My lord. This is the committee who has passed the order, my lord.
Yes. That you have submitted.
My lord, this is the committee, my lord, here, director, my lord, superintendent of police, my lord, he is in the vigilance cell, my lord. So he cannot be a, my lord, member in the state SLC, my lord. Secondly, my lord,
Just a minute, just a minute. You say what, superintendent of police, what have you
well,
stated?
this superintendent of police cannot be a member because he is in the vigilance cell, my lord. So he is deciding his own report in the, my lord, SLC, my lord. Otherwise, he can be a member if he's not in the vigilance cell, my lord.
Okay,
And
okay.
as per Madhuri Patil, my lord, the direction 5, my lord, only senior superintendent of police is to be, my lord,
Senior deputy superintendent,
superintendent of police and
deputy superintendent.
deputy superintendent of police, my lord. Then, so, and my lord, the annexure 6 also, my lord, under silence, my lord, let me come to 7, my lord, not sorry, annexure 7, my lord, page 55.
Okay,
Here is my lord,
Annexure?
the 7, my lord, page 55.
5. Yes,
My lord, here, my lord, the Constitution Committee not as per the Madhuri Patil's direction, my lord. Even not according to the office, their office memorandum, my lord. So,
this
my
is,
lord, here is a,
this is the correct committee.
my lord.
This as per you is a correct committee.
No, my lord. It is not. The vigilance cell is only deputy, senior deputy superintendent of police, then other officers, my lord, inspector.
Hmm. But this is not the committee which has looked into your matter.
Their vigilance cell is close to my here. The in person of the government member of a vigilance cell hereby constituted.
Yes,
So here is director himself, director, my lord, who is a member of the SLC, my lord. Deputy director, my lord, he is immaterial, my lord. The deputy superintendent of police is there, my lord. Then, my lord, police, 2 police inspector, so one of these Joduram Kakoti. And both the report is submitted by the Joduram Kakoti, my lord. The favor
This-
also
this-
against also,
This committee is a committee under, as per direction of Madhuri Patil.
my lord,
It's the nomenclature will not make any difference.
my lord.
Vigilance cell constituted to deal with matters relating to fake caste certificates.
My lord, my lord.
But the committee which looked into your matter is not this committee, it's a 5-member committee. Which
According to Madhuri Patil, it should be, my lord.
that you have already said, so you need not refer to this committee at 55.
No, this is one under silence, my lord. This committee has submitted report, that is, my lord. Perverse, my lord, ultra
Oh,
violence.
this report by this committee is which page?
My lord. But this, because, my lord, though Joduram Kapoti has submitted the report, this is, the director has to take a decision as per Madhuri Patil case. Individually, my lord.
Yes,
His report is whether right or wrong, or he will go for further inquiry.
yes.
Not by this committee. Committee is only that senior superintendent of police and the police officer. They are not included, my lord.
See, the final call will be taken by the director or by the committee. It was by the committee.
But as per the Madhuri Patil case, director has to decision whether he will forward to the committee or not.
Let us see.
My lord, this Madhuri Patil case, my lord. Director, okay. 5. Hmm? 6, my lord. Direction 6.
The show cause was issued by whom?
Director, my
Then
lord.
where is the aberration? Where is the violation of law?
No, my lord. I am saying, my lord, here is the vigilance cell is to be by only 3% or 4%. But senior superintendent of police will be the
Yes,
under his, my lord, overall in charge, my lord. The
Yes.
inspector will do the investigation.
yes.
They will submit to the director. The director, as per multiple, he take a decision, my lord, because the vigilance cell is considered under, my lord, his, my lord, authority, my lord, as per the Madhuri Patil case, my
Hmm.
lord. So the director has to take a decision, my lord. The cell is taking a decision, my lord. Though director is issuing the so-called notice, my lord, cell is taking a decision. And this cell is the director is involved in the cell, my lord. So there is no independency. Whatever inquiry that is influenced by the director, my lord, or by the someone, my lord, who is not supposed to be a member of the vigilance cell, my lord.
Okay.
My lord. Secondly, my lord, the against this, my lord, show cause notice, I have, my lord, filed my lord,
Reply.
reply to the show cause notice, my lord. That
Yes.
has been not discussed at all, my lord.
That you have submitted.
My lord.
That we have,
And secondly, my lord, that has been not supplied to us, my lord.
that we have said.
I have prejudice.
Copy of the
Though
complaint.
I have got in the second time, my lord, I have prejudice, but I have clarified, my lord,
Okay.
in the second
Okay.
instance.
Okay.
My lord, the entire, my lord, impugn order is not on the basis of the direction of the Madhuri Patil, not on the basis of the, my lord, office memorandum issued by the authority himself, my lord, the Annexer T, my lord. This is the office memo, Annexer 5, Annexer 4, my lord, office memorandum, my lord. On the basis of Madhuri Patil, same, my lord, for the direction we reiterated in the office memorandum, my lord. So as per this, that has been done not, my lord. The inquiry has been not conducted by the vigilance cell as per the directive of the Madhuri Patil case, or not on the basis of Annexer 4 11 May 2018, my lord. And secondly, my lord, the committee is under silence, both the committee, my lord, state level committee, not as per the procedure. The cell also under silence, my lord. And the, my lord, the inquiry report, my lord. First report, first report is in favor of me, my lord. Second report, there is no occasion to go for second report without a, my lord, decision by the director, my lord.
Yes.
And the minutes of the meeting, my lord, are absent even 11/11/2020, my lord, where the respondent petitioner has appeared before the committee, no minute. On that, while passing the impugn order, my lord, there is a no minutes, my lord. Even last annexer, my lord, I have applied for the minutes, my lord. All this, my lord, they have said that, my lord, is not available on record, my lord. Page 126, annexer 30, my lord. They failed to give, my lord. That means, my lord, the impugn order has been passed mechanically, my lord. Now, my lord, this is the motion says, my lord. Only my thing is that the petitioner is the, my lord, the member of parliament, my lord. The next, my lord, 18th election is, my lord, anything, my lord, by the tomorrow, day after tomorrow, notification may come, my lord. If, my lord, lordship, my lord, not interfere with the, my lord, impugn order, saying the impugn order, my lord, the client will be, my lord, I'll be deprived of primary contesting in the election, my lord. That's the entry may be considered, my lord. My lord, after
You are
my
intending to
lord,
contest.
my lord,
You are an aspiring candidate.
my lord, my lord. And one thing is that, my lord, that I have not taken as a ground, my lord. They have done everything in 2020, my lord. Why they have waiting for the before the election, my lord? They politically vindicated, my lord. They have did everything, my lord, in 2020. There is no 2022, 23, nothing. Only 2000.
Impugned order is a which date?
My lord, the 12/1/2024, my lord. The eve of the election, my lord. This is politically, my lord, motivated order, my lord. How this, the, my lord, SLC restrained to pass an order? Maybe against me, maybe in favor of me. I could have taken measure on immediately, my lord.
Okay. Yes.
My lord, I'll supplement, my lord. If it's that, my lord.
The impugn order was not issued at the eve of the election, lordship. It was issued 2 months ago, and there is a huge delay on his part to come before the report after 2 months of issuance of the impugned order. 12th of January 2024, the impugned order was issued, and today we are on 15th of March or 14th of March. So there is a huge delay, 60 days delay in this matter, lordship. So that is why my first submission, lordship will kindly give me 3 days time to give a complete affidavit, because the facts which he are placing are all lopsided. So I will place everything, but if lordship is pleased to look at page 63, the report, the first report. It's a very incomplete report where page for 63, paragraph 2. May I read it, lordship? For verification of caste certificate of Nobo Kumar Foronia, MP Kokrajhar, I visited given address, examined the persons noted and other prominent persons of that locality and found that the said persons belong to Foronia Kosari community which is under the purview of STP category. So who are this person he have visited, made, nothing, no details are there. I collected the copy of letter issued by the government of Assam for welfare of plain tribes and backward classes, Dispur, Guwahati, referred in letter dated 15 June 2018, addressed to all deputy commissioners, directing to issue STP certificate to Horonia Kosari community as Kosari tribe in Assam. For ready reference, I am enclosing a photocopy of caste certificate along with the
In
government
fact,
letter.
that we have read. The
That
second
is
part.
it. Now
No,
coming
Mr.
to next,
Mr.
what is there?
No, no,
Lord will
the
kindly come to second.
second part may not be a part of the inquiry. That is already know that if one is a Saranya Kosari, he belongs to ST. That is not the part of the inquiry. Inquiry is whether he belongs to a Saranya Kosari.
Exactly, Lordship. That is why Lordship will kindly come
So
to now. the
first part is of prominent importance, whom he have examined to come to a conclusion
Exactly.
whether
Lord.
the petitioner
For
belongs
that,
to.
we have to go to the ancestors' caste status, the legacy data verification, the land documents, various admission, birth certificates, hospital, etc. Those things, Lordship will kindly come to the second report at page 74.
But
And second report is just a continuation.
But is there any note in your file or
That
any
I have
order?
that is that I have got the
Whether
file.
you have discarded or you have found
No,
come
we
to
have not discarded. Lordship will see the first line of the second report,
Okay, page.
page 74.
Yes,
In
please.
inviting reference to the subject cited above and in continuation of the previous report. Because previous report was silent on the most vital factors. As per the Madhuri Patil's paragraph 13.5, nothing is there.
Oh, interestingly, this is by the
And in
same
continuation,
and by the same officer.
by the same officer,
Oh, there is no
That's-
change of officer.
no
There's
change of
somebody.
officer. And therefore, what was the direction? By 11th May 2018, find the details of his ancestors' caste status, legacy data verification, land documents, and admission report in educational institution. All these data he have further collected. And therefore, in the impugn order, Lordship will kindly see page 112.
This is dated what? The second page
Second
74.
report, Lordship,
74 is dated.
that's why I have to place the fact in a proper way.
Dated it 4-2.
4/2/2020. Thereafter, the SOCOS notice was issued, and he took more than 1.5 years to submit the report on the pretext of COVID.
No,
I have gone through his reply, Lordship.
20 I have filed.
I have gone through his SOCOS reply also.
When was the date of the reply?
Reply that. Wait a minute.
31st August 2020, first one.
Okay.
Second one, 21/12/2020. Within that 20, I have.
Okay.
So here he has taken the plea of COVID, and also there is sub judice matter in the Honorable High Court to in delay in submitting the report. And in the impugn order, he was given both the report, the first report and the second continuation report. And thereafter he was issued SOCOS, and he has replied thereafter, after both the reports were given to him. And at no point of time he has raised number 1 regarding the constitution of the committee, regarding non-submission of any documents to him. If he was not furnished with any report, where is his request to give it? Page 112.
112.
Yes. It's the part of the impugn order, second page of the speaking order.
Yes.
Whereas on receipt of the first report from the officers so and so issued SOCOS notice to Nobo Kumar Horonia on 11/2019. Whereas Nobo Kumar Horonia filed petition dated 8/4/2020 and 16/18/6/2020 sought extension of time to submit his replies, and later submitted his replies on 31/8/2020 to his SOCOS to the director of WPT and PC department. Whereas Jonoklal Bosumati submitted his replies to the SOCOS notice dated 21/9/2020. Whereas CID in the meantime submitted their second report number 4/3/2020. Whereas on receipt of the second report from CID Vigilance Cell held on meeting on 14/9/2020, decided to refer the case to the state level scrutiny committee dated 18/9/2020. Whereas hearing of the state level scrutiny committee was held on 11/11/2020, the committee heard Nobo Kumar Horonia in person and perused his stand as reply dated 31/8/2020 to his so-called notice submitted to the director of WB. So everything was to his knowledge and he has responded. He has submitted to the jurisdiction of this committee. He has accepted the constitution of the committee. Now, after 4 years, when the report went against him, and the committee was also initially 5-member, then 6-member, then it was reduced to 5 members because there is a subsequent Supreme Court judgment also that it can be of 5 members of 1997. So Lordship will kindly give me 3 days time to give a detailed affidavit, and thereafter Lordship may take up the matter because I do not want to deprive the writ petitioner also from contesting of the election. But let the complete facts be placed before this honorable court. Otherwise, today, if Lordship grants an interim order, he participates in election, and after in the month of May, the writ petition is dismissed, the whole people of that particular constituency will have to face another round of election. So that's why 3 days time may be given to us. By Monday, we'll file the
Are you
affidavit.
contemplating to issue notification for elections?
2-3 days, I do not know if that election commission has that prerogative, but they will give 14 days, huge time will be there for submission of nomination paper. So by next week,
Mr. Das, you are for? 8 is the complainant. Okay, you have something to say today?
It's not to be followed, I don't. It is not to be followed. So not to take the public.
and prima facie Lordship, he has no case at all because his community, whatever he is the coach community. Coronia, that is does not follow into tribal STP or STPH. Prima facie Lordship. Forget about all these procedural lapses, what they are alleging. In fact, there is no procedural lapse. He was given full opportunity. In either case, either procedural lapse, there is none, nor violation of any principles of natural justice. There is no arbitrariness. And on top of that, suppose procedural lapse is there, but whether on merit he has a case. He does not have a case on merit. As on that, we have tried to bring his community under scheduled caste tribe.
Scheduled tribe,
Scheduled tribe.
plains.
That process is going on, but till now that nothing has fructified. The file, I have gotten the file. So let me file a detailed affidavit in 3 days time, Lordship. The records are with me. We do not want to delay also. We do not want to deprive also.
Status quo till then, my lord, what, my lord?
Status quo, yes, status quo, I am agreeing.
No, we'll have, AG's submission is reasonable. He is only praying for 3 days time. Today is Thursday.
My lord.
Let the affidavit be filed by Monday.
Monday and
We'll have,
Wednesday, Lordship may take up the
we'll
matter.
have this on Wednesday.
Then my lord, interim order will consider.
No, we'll consider the entire matter. If the affidavit is filed,
We'll file, Lordship.
and you can
the
press,
commitment before
you
this
can very much press with the interim order. In fact, we are considering this hearing which you have held was only in consideration because, see, examining the matter is not a problem at all. We'll
My lord,
examine
My lord,
definitely.
my lord.
But
Really,
the-
it will be
But
examined
the
because my lord,
contentious issue comes at the point when you press for an interim order,
my lord.
and which has been obviously resisted by the other side. We'll consider that. But you ensure you file it by Monday, so that
100%, Lordship. We'll
he
ensure.
gets time. Mr. Das, you would
We'll
like
give
to
an
file,
advance copy to the other side.
would like to file affidavit? Not required. Third. 3 M. Saranya, Learned Counsel for the petitioner who has put to challenge a speaking order dated 12/1/2024.
Dr. May I
Passed.
quickly proceed?
Yes, yes. Passed by the committee, by the state level scrutiny committee, whereby the petitioner has been held not to be belonging to the scheduled tribe plains community. Full stop.
Borokosari, my lord. My claim is Borokosari.
Full stop. It is the contention of the petitioner that he belongs to the Boro Koshari community, which is a recognized,
Notified scheduled tribe
which is a notified scheduled tribe trained community,
by presidential
And-
order.
and is also presently a member of parliament on the strength of such social status.
Right.
Full stop. Sri Saranya has made detailed argument and has also prayed for an interim order. Full stop. Para. Sri D. Sekya, learned Advocate General Assam, however, has resisted the writ petition and also the prayer for interim order. Full stop. He submits that since there are contentious issues, comma, the interest of justice would be served if the respondents are given an opportunity to put on record their stand by way of an affidavit, for which, full stop, the learned AG prays for. The learned AG further submits that in view of the urgency expressed, comma, such affidavit would be filed as soon as possible, and in any case within a period of 3 days from today. Full stop. Para. Also heard Sri B.C. Das, Learned Senior Counsel, for the respond number 8. You're on caveat,
Caveat, my
who appears, assisted by Sri S. Chauhan, appearing on the strength of a caveat lodged. Full stop. Para. As agreed to by the parties, comma, let the affidavit in opposition by the state respondents be filed on or before, filed by 18th of March. 18th March? Today is what? Monday, 18th of March, and the matter be listed for consideration on 20 March 2024. Full stop. Caveat to record দিব। Heard Sri B.C. Das, Learned Senior Counsel, assisted by Sri S. Chauhan, Learned Counsel, who has lost this caveat with regard to an order dated 12/1/2024, passed by the state level scrutiny committee, comma, under the Department of Tribal Affairs, within bracket plain, Government of Assam. Full stop. Para. The caveat would be heard in the event this court proposes to pass any interim order. Full stop. Para. Caveat stands the church. Okay. Wednesday.
Right.
File it by Monday.
I'll have it.
এখানে লাগিব দে। Save এখানে। এখানে মোৰ এটা থাকিব পিছত টিমটোত।
It would be possible for time being. My senior is on next.
My lord, here is there, my lord.
Who's for the applicant?
Lord, we are for the applicant, my lord.
You have come for vacation of
My
the skill.
lord, in fact, and it had been heard also, my lord, an order, a detailed order had also been passed. My lord, may be pleased to find it is on record, my lord, on 5/3/24.
Hmm.
My lord, only difficulty is that, my lord, there is no, my lord, the matter has been kept pending, my lord. We, my lord, respectfully pray before my lord, my lord, that the entire writ petition can be disposed of relying on this order. My
Let Mr. Chaliha
lord.
come.
My
Okay, after a while.
lord.
Yes.
Well, we have challenged the order passed by the Assam Board of Revenue in review petition. Well, my learned friend has just now submitted a copy of the Tamabandi, which reflects that the order of the Revenue Board has already been implemented. In the view of the matter, my lord, I may be given some time to get instruct, because only this morning he gave me next month.
14 matter.
My lord, question is that, my lord, the petitioner purchased the plot of land from one Akramal,
Petitioner.
a peasant. Thereafter, petitioner sold the land, my lord, to us. Thereafter, we got our name muted. Thereafter, after a gap of, I think, 20 years, he filed an application before the Revenue Authority for mutation of land. We filed a bit.
His petition was for mutating his land, his name
His-
again.
Yes. Now, our name was mutated in place of Akram Ali, not place of petition. And this, my lord, this Revenue Authority, my circle officer.
Who was Akram Ali? His vendor.
Earlier, my lord.
His vendor.
Yes, his vendor.
So he purchased from Akram, sold
Akram.
it to you.
Sold it.
And while the mutation was done, it was done directly from Akram to your name.
Agreed.
Okay.
Then he filed we filed an objection. Thereafter, their petition case was dismissed. And thereafter, appellate authority also dismissed their appeal. It came to the Board of Revenue.
ABR.
Board of Revenue came to the finding that this mutation was not proper. That in place of Akram Ali, it should have been in place of Basir Mia. That means petition. And thereafter, our mutation order, which was never challenged before any revenue authority, my lord, that was cancelled. We filed a review. And review, it was clarified that we have not actually, this is not our intention. Intention is this: first Akram Ali, thereafter Basir Mia,
Basir,
thereafter.
Daniel. Oh.
So that was done. That was done in part.
Is there anything to be?
My lord, this
We record your submission and close it. Okay, heard. Sri S. Sharma, Learned Senior Counsel. Assisted by Sri B. Deka. P. Deuri. P. Deuri. For the petitioner. Also heard. Yes, Revenue. Ms. G. Hazarika, Learned Counsel, Standing Counsel, Revenue Department, comma. Ms. M. Borman, the State Counsel, and Ms. M. Borman, State Counsel for Subsidy. M. Sharma, Learned Counsel appears for the
12 to 16 year.
private responder was 12 to 16. Full stop. Para. A brief narration of the facts projected by the petitioner would be convenient. And is given as hereunder. Full stop. The petitioner had purchased a plot of land in the year 1980 and had applied for mutation of the said land in the year 2008. Full stop. Though no objections were raised by the vendor of the petitioner, comma, one Samim Ahmed Talukdar had, within brackets, respond number 12, had raised an objection. Full stop. In the said objection, comma, it was stated that the petitioner had in the meantime sold the land to the said respond number 7. Respondent number 12,
12 to 14.
12 to 14. And therefore, the application. No, 14, full stop. Considering the said objection, comma, the application for mutation was rejected. Full stop. Para. The aforesaid order of rejection was the subject matter of an appeal preferred by the petitioner before the Assam Board of Revenue. Full stop. The ABR, the learned ABR, wide judgment dated 13/12/2012 had allowed the appeal and directed for mutation of the name of the petitioner over the plot of land in question. Full stop. Para. The respondent, private respondents number 12 to 16 thereafter had filed an application praying for review of the judgment dated 13/12/2012 of the ABR, of the learned ABR, which was registered as review case number, which was registered as 4RA within bracket N within bracket RVW bracket close oblique 2013. Full stop. The learned ABR, after considering the matter, had clarified the earlier judgment by directing that the mutation of the land in the name of the review applicant bracket respondent numbers 12 to 17 is not liable to be interfered with, and it is only required to correctly put the names as the said respondent numbers 12 to 16, 17 or 16 had purchased the land from the petitioner, and such transfer was not the subject matter of challenge in any proceedings. Full stop. Para. Sri M. Sharma, the learned counsel for the respondent numbers 12 to 16, has submitted that pursuant to the aforesaid order, what has happened?
Well, this mutation was that it was modified. In place of Akram Ali, the name of petitioner was deleted. Thereafter, in place of
Has info, okay, M. Sharma. Order, comma, the due correction in the mutation order has been made, wherein the name of the petitioner has been inserted after the name of the original vendor, Akram Ali, and thereafter the names of the respondent numbers 12 to 16 have been correctly reflected. Full stop. Para.
Thereafter, Basir Mia.
No, you have
Akram Ali to Basir Mia.
already said.
that is it.
Petitioner, there and there, full stop. Para. Sri Sharma, the learned senior counsel, however, submits that
Then, my lord, my point is this, my lord, in the review order at page 33, in view of the findings, we are of the opinion that there are no any error apparent on the face of it. If there is no error
submits that power of exercise can be, the power of review can be exercised only on certain conditions, and there being a finding that there was no error apparent on the face of the records, comma, such powers would not have been exercised. Full stop. Para. This court has, however, noticed that neither the transfer to the respondent numbers 12 to 16 is the subject matter of challenge, nor the the reflection of their name appears to be an erroneous exercise, full stop. The order passed by the learned Board of Revenue in the review petition dated 6/12/2023 appears to be in order inasmuch as only a correct reflection of the names in the mutation order was directed, full stop para. In view of the above, this court is of the considered opinion that no case for interference is made out, and accordingly, the writ petition stands dismissed.
Item 7, time being.
May I please the lordship? My lord, in fact, this matter has came up on being mention made by on our behalf, my lord. Plus, what has happened, my lord, a writ petition has been filed challenging the construction of an Anganwadi center, my lord. And there are some land disputes the writ petitioner have alleged. And now, my lord, the circle officer has placed a report, my lord, before this honorable court. And basing on that report, my lord, in our IA, my lord, has a detailed order had been passed on 5/3/2024, my lord.
Hmm.
My lord, in fact, on that day, we prayed for that the land can be demarcated, my lord, in accordance with the provisions of the Public Service Premises Act. And the, my lord, office memorandum is there, my lordship is well aware, my lord. So, my lord, if any land dispute is there, my lord, the writ petition can be disposed of, my lord. Then the demarcation can be done, my lord.
When
and
such
it
an
can be
order has
settled.
already been passed, can that order be bypassed now?
No, my lord,
At
it
this
is in the
stage,
interim order, my lord,
it is
I am
not- it
praying
is
for
not-
the
So
main
it
writ
is not for
petition.
whims and captures of the petitioners, my malandro faith. That has to be adhered to. 5/3 order has been passed.
5/3 has been passed. What is
Yes.
the order?
What should we find it? Is a detailed order
To
It is on
define the
record, my
matter.
lord.
in the light of the submission. Last portion I am reading.
Yes, please read.
In the light of the submissions made by the learned counsel for the parties and on perusal of the letter 4/3/24 faced by the learned government advocate, this court deems it appropriate to direct the circle officer, Borkhetri Revenue Circle, to conduct a proper survey of the land allotted to the petitioner. Under Dag number Iman in Borkhetri Revenue Circle, Moja, Moitham Borkhetri, and submit a detailed report stating therein as to whether the land measuring 1 kata 10 lesser of the land under government
Oh.
Dag number.
Has this
101.
has this report come?
No,
No,
no.
no.
4 weeks time has been given.
60 days time, yes, you're
Yes.
right. Yes,
Time has been
sir.
given. How
Yes,
the
sir.
question comes up now?
Mr. Sharma,
Uh.
report has come.
Yes, Lord, that the report is already there.
No, after this order.
No, Lordship, that see, earlier we have been directed to make a survey and to submit a report.
Correct.
Accordingly, on 5th, Lordship, I have submitted a report. That report is addressed to me. That is a part of the record, Lordship, if it is not before your Lordship. But I have supplied it, and I think, Lordship, it is kept as a part of the record. It is a letter addressed by the Additional District Commissioner Nalbari to me, Lordship.
I think you have given in the writ petition.
Copy.
This is, yes, Lord, this is the copy.
Date.
That is dated 4th of March.
Oh, yes, we have this. That as reported by the circle officer.
This situation arises because of our affidavit, the annexures.
No, what is the meaning of the paragraph which Mr. Chalia has just referred to?
Lordship, actually,
because-
Lordship,
4/3/24, your letter has been considered by the court.
Yes.
And thereafter some,
Thereafter the court has passed.
yes, sir. What has been said? Please read again. Do you have that order of
yes,
5/3?
yes, yes, I have.
Please read in the light.
in the light of the submission made by the learned counsel for the parties and on perusal of the letter dated 4/3/2024 placed by the learned government advocate, this court deems it appropriate to direct the circle officer Borkhetri Revenue Circle to conduct a proper survey of the land allotted to the petitioner
Yes.
under DAG number 1415 in Borkhetri Revenue Circle, Mouza,
Hmm.
Modhyam Khetri, and to submit a detailed report stating therein as to whether the land measuring 1 kata 10 lesses of land under government DAG number 101 is in occupation of the petitioner, that is Sakla ME Madrasa in excess of the land measuring 3 kata 15 lesses, which has been allotted to the petitioner under DAG number 1415. In this report, may I please, in this report which is addressed to me, here it is specifically mentioned 2 kata 10 lesses of land covered by DAG number 101. Kata is under the position of. So, Lordship, on that day, most probably we are unable to place the thing properly before the honorable court. All of us were in agreement that let there be a
Demarcation.
let there be a demarcation on the basis of the revenue records by the circle officer. And to settle the land which they are belonging to, if they are occupying, after the demarcation, everything will be clear, as because that is the, apart from that, Lordship, no order can be passed by this honorable court under Article 286. As because if there is a dispute, that disputed question of fact cannot be taken into consideration by this honorable court. So that was the, most probably we were unable to place that thing properly before that honorable court. But that report is already here. The same report will come again, Lord. That is where we are praying that let the matter be disposed of, directing the circle officer to demarcate the land on the basis of the revenue record. That was our prayer. Let. Taking that was actually, Lordship, all of us were have prayed like that, but most probably we are unable to place the thing properly before the honorable court.
The petitioner is the madrasa or what?
Writ petitioner is the Madrasa.
And you are the
I am the
Anganwadi.
Anganwadi Center, my lord. Our construction has been on hold, my lord.
Because they are enjoying a stay order.
Stay order, my lord. Small kids are
Demarcation
suffering,
has
my
found that out of 2 kata 10 lesser of land covered by government so and so, 1 kata is in possession of
School, my lord.
the Anganwadi Center.
Anganwadi Center and
And
rest
1 kata 10 lesser is under the position of Chakla Ami
Chakla Ami.
Madrasa School.
That is our land, my lord.
This report, Lordship, we have been directed to bring this report basing on the affidavit filed by us. If your Lordship kindly come to our affidavit.
But is the madrasa still functioning as on today?
Yes. It is now being, my lord, transformed into schools, my lord, and it has been amalgamated some other schools, my lord, from our instruction. Not as a madrasa, as a school, or as a school, as a school.
Mr. Sharma,
Lordship.
see, rightly or wrongly, there is an order of this court.
My lord.
You may submit, you are correct that it will be a, in fact, empty formality kind of a thing, asking you to direct the same report. But there is an order.
There is an order, my lord.
There is an order. You can just refer to this order and have a report. We can then at least, because it will not look proper.
Lordship.
And
We have.
why more so when this order is of a subsequent date, and more than that, 5-3 has taken into consideration 4-3 communication.
Yes, Lord.
So if 4-3 was already in the mind of the court,
Lord.
thereafter certain directions have been passed, we cannot go into the correctness of the direction. You have a report and maybe 2 weeks,
Brought to the,
Two-
from their instance.
2 weeks time. But
Mine.
we'll fix a date. We'll
My
fix
lord,
it.
my lord, that can.
Just to overcome the formality.
Lordship.
Okay.
My-
Heard Sri DP Chalihal and Senior Counsel for the writ petitioner. Also heard Sri H. Sharma Learned, Additional Senior Advocate Assam. Whereas Sri A.R. Bhuya Learned Counsel appears for the number
Respondent number 10 in the writ petition.
10, who has also filed the connected IA
351.
3519 of 2023 for modification of the interim order, fourth para, in the aforesaid IA, comma. An order has been passed by this court on 5/3/2024 directing the circle officer, comma, Borkhetri Revenue Circle to conduct a proper survey of the land allotted to the petitioner. And also with regard to the land under the occupation of the respond number
My lord, 10.
10, full stop, para. 3. Shiv Sharma, the London State Council, however, clarifies that the communication dated 4/3/2024 would clarify the aforesaid aspect. Full stop, para. This court has, however, noted that the aforesaid order of 5/3/2024 was passed after consideration of the letter dated 4/3/2024, which was placed on record. Full stop, para.
That was not placed on record, most probably, Lord.
It was
That
placed on record.
may-
placed on
Yeah,
record.
Lord.
Para. In the fitness of things and to maintain a judicial decorum, comma, let the exercise directed by this court by order dated 5/3/2024 be carried out. And no, don't say carried out. Let the outcome of the exercise directed to be carried out by order dated 5/3/2024 be informed to this court within a period of 2 weeks from today. Full stop. Para. Considering the nature of the dispute, comma, an endeavor would be made to finally dispose of the writ petition on the next date.
Lordship is fixing a date.
Tell us,
As per your lord.
list
Lord.
on
27th of March.
11 on, today is 15.
Let it be on 28, Lord.
We'll have it on 1st of April.
First.
1st April.
March.
Chalia, 1st April is okay for you?
I'll not be here. My third people.
No, you tell us a date if you want to be there. We will accommodate you. 28th,
I'll be away for some time.
from when are you go? Will not be
From
available.
before to till April.
No,
you-
then we'll fix a date on 1st of April.
Apply.
Lottery,
14 matter,
14 meter lottery. I'm agreed by annexure 3, page 19 lottery,
page,
page 19 lottery. What happened lottery? The IOC advertised for filling up some ASK kerosene depot. So I applied
advertise of which date?
advertisement of 26 January 2012. Last will find it.
26 January, how can an advertisement be issued on 26 January?
It was in the newspaper.
Cannot be.
Annexure 15 lottery.
26 January, is there a newspaper?
Lordship, some people thought. Page 15 lottery.
Okay, the newspaper doesn't come on the next date. 26 it comes.
It comes. So Haldi is on 26th. 27th, no newspaper.
Okay.
So lottery
26 1
2012 lot.
12 advertisement for
TSK Kisan Seva Kendra retail outlet.
Kisan Seva
Kendra retail outlet.
KSK retail outlet for
For I applied for lordship. Will find it page 15. Last serial number 53 lot.
retail outlet for what?
Kerosene lot.
Sir, it's rural area.
Rural
Kisan-
areas, okay.
Kisan Seva Kendra. Diesel, petrol, briquette,
Where is kerosene written?
kerosene is there.
In the total advertisement, I think it's there.
Non-agro product.
Non-agro is not kerosene. Okay, doesn't matter.
Lordship, so I applied. Lordship,
For SK oil,
KSK, Lord.
SK oil, it's called SK oil, isn't it?
KSK, Lord. SK, Lord.
What is SK oil?
Super
What?
kerosene.
Huh? What is SK oil? Not Shahrukh Khan oil.
Sir,
Yes.
Lordship, what happened, Lordship?
Then
I applied for Lordship 3 number 53, last.
location.
Location, Lordship.
Location. Petitioner applied.
Lordship. 3 number 53, Lordship. Vishwanath Sarili to Pavoi Road.
Hmm.
And Lordship will find the categories open.
Vishwanath Charali. Abhoy. Abhoy Road. Category open.
Category open.
Okay.
So after my application, Lordship,
Hmm.
I was shortlisted. Now, Lordship, may peruse page 19 and 3.
19.
19.
You are given call letter.
Lordship.
18.
18 is my call letter.
1910.
1910, Lord.
Then
Then, Lordship, annexure 3, page 19. This
call
is-
letter fixing when?
Lordship.
6/11.
Lordship.
Fixing 6/11/2012.
12. 14.
Yes. 19 is here.
Cancellation, Lord.
No, shortlisting.
19 is cancellation, Lord. 19.
No, cancel. You're shortlisted. Decide to cancel the interview.
Cancel, Lord.
Oh, 19 is the impugned order.
Impede order.
1912.
19.
Interview
12,
was cancelled.
Lordship, interview was cancelled. What happened, Lordship? May I read, Lordship? This is for your kind information that you were shortlisted among other candidates for KSK dealership interview at the location such and such. Sonitpur under the open category.
Hmm.
Against advertisement published in newspaper such and such.
Hmm.
Honorable Guwahati High Court order in the WPC number so and so, dated so and so, pertaining to the above notice CSK dealership at the location Business Pavoi Road. The corporation has decided to cancel the interview conducted on 6/11/12. Guwahati to comply with the order passed by the Honorable High Court in WPC number such and such. So, as per this letter, the interview was cancelled for complying with the order passed by this Honorable Court.
Yes.
Lordship, I have annexed the order, Lordship. The order nowhere says for considerable, I have annexed the order, Lordship. Page 26, it's thus, Lordship.
26.
Lord. Annexure 6. Relevant parts are page 26, Lord. May I read, Lord? I heard Mr. R. Dubey, learned counsel for the petitioner, also heard Mr. Swatantra, learned counsel for and standing counsel IOCL. I have also heard Mr. U. Rajvanshi, learned counsel representing the respondent report. The petitioner is aggrieved by the rejection of his candidature for Kisan Seva Kendra to be set up at Business Pavoi Road in the district of Sonitpur. As per the requirements of the
Mr. Chakraborty, what is your name?
my name is Deepak Burwal.
Okay. You're not Arun Kumar Singh.
No, Lordship. So,
No.
what happened, Lordship? Arup Kumar Singh also filed an writ petition. It was tagged
Okay.
with this petition only.
Okay.
Due to non-appearance, it was dismissed on the last occasion
Okay.
for non-appearance.
Now what happened here?
Lordship,
Page 26.
page 26, Lordship, I'm reading, Lordship. The petitioner agreed by the rejection of candidature for Kisan Seva Kendra to be set up at Business Pavoi Road in the district of Sonitpur. As per the requirement of the condition to apply, a candidate is required to submit permanent residence certificate of the district. The petitioner submitted an Annexure 4 PRC dated such and such, issued by such and such petitioner thoroughly. By the state certificate, he was certified to be a permanent resident of Sonitpur and the certificate was issued for educational purpose. Referring to state certificate, the authority of in the ISL rejected his candidature on the ground that the state certificate was issued for educational purpose only.
Hmm.
As per clause 2.2 of the notice of the appointment, CSK, the applicant should be resident of the concerned district as per the certificate issued by the deputy commissioner as per the such. The petitioner was issued with the certificate issued by the SDO, clearly certifying that the petitioner is a permanent resident of Sonitpur district. Having certified as such, this is immaterial as to whether the same was for a particular purpose. The question for determination as to whether the petitioner is a permanent resident of Sonitpur district or not. He having been certified to be so, the authority of ISL could not have called in question the said certificate merely because it is also indicates the purpose for which certificate was issued. In view of the above, the writ petition is allowed by setting aside and quoting the annexed later latest circumstances in terms of interim order passed circumstances. The petitioner's candidature has been already considered by ISL. Now, they will finalize the matter in accordance with law as quickly as possible. So, in the order, there is no mention by the Honorable Court for cancellation of the advertisement, as has been projected in page 19, Lord.
Okay,
After cancellation, Lordship, they published press advertisement, Lord.
Hmm.
That is at page 20, Lordship, Annex 4.
dated,
Dated, Lordship, 25th of October 2014.
yes,
And my location is page number 28, Lordship. Is a type copy, Lordship.
Biswanath Charlie. Yeah.
Yes, 82, still number 82, Lordship.
Hmm.
What they have done, Lordship will find they've changed the category.
Hmm.
Now it has become reserved for SC, Lordship.
Hmm.
So due to this, Lordship, I am also debarred from applying in this advertisement, Lordship.
Okay,
I got stuck in this, Lordship.
okay.
This is my Lordship. Only thing, Lordship, now my learned friend has informed me that they are going to cancel this advertisement also.
But much deliberation took place on a last occasion. So I took the liberty of this honorable court, seek instructions whether since 2014 advertisement, whether we are going to go ahead with this or not. There's a lot of
Time.
guidelines have come into place in the meantime. It
Yes.
changes the policy.
A decade has also passed.
Yes. And I was instructed that yes, the IOCL is not proceeding with these advertisements. And this submission was recorded in Purut Kumar Singh's order by which it was dismissed for non. That order, so we are not proceeding. If we re-advertise once again, then you will have the liberty and part.
But whether it be an SC or an open category,
That
We always go by the roster followed by all oil marketing companies. So whatever falls for that particular location,
it
only
is not necessary that one is earmarked as SC, it will be SC. It may not be.
200-point roster is before.
only I am agree, Lordship, the reason for cancelling the first advertisement. The reason is doesn't tell you with the Lordship, the cancellation orders.
Courts, this honorable court bar us from cancelling. In the meantime, while the process was going on, the ministry directs us to cancel these advertisements because the new policy was formulated to conduct the entire selection process through the draw process instead of the interview process. This is for maintaining transparency. That's why we went ahead with the cancellation and we did.
Okay. Third, Sri S.K. Chakraborty, S. Chakraborty, Learned Counsel for the petitioner also heard P. Bharadwaj, Learned Counsel representing the Indian Oil Corporation respondent. Full stop. Para. The facts connected may be narrated in brief in the following manner. Please have your seat. An advertisement was published by the Indian Oil Corporation for allotment of KSK retail outlet. Advertisement was published by an advertisement dated 26/1/2012. KSK retail outlet for, amongst others, SK Oil. Full stop. Again, serial number 53, location, which is Biswanath Chariali, Pavoi Road, comma. The petitioner, who claims to be eligible, had applied. Full stop. The location was categorized to be categorized the location was under the open category, open to inverted comma, full stop, para. Pursuant to such application, comma, on 19/10/2012, comma, a call letter was issued to the petitioner fixing the date of interview as 6/11/2012, full stop. The interview was accordingly held, in which the petitioner was shortlisted, full stop. However, comma, via a communication dated 19/12/2013, comma, the petitioner came to know that the entire process was cancelled, and such cancellation was pursuant to an order dated 14/6/2013 passed by this court in WPC, in a writ petition, WPC 4198 of 2012, instituted by one Asim Jyoti Bora. Full stop. It may be mentioned that in the said writ petition, comma, one Arun Kumar Singh was the private respondent number 4. Full stop. Para. Sri Chakraborty, the learned counsel for the petitioner, by referring to the order of the High Court, or order of this court dated 14/6/2013, has submitted that there was no direction for cancellation, and the direction was only to consider the case of the petitioner, of that case, whose case was already under consideration as per an interim order dated 4/9/2012. Full stop. He accordingly submits that a wrong interpretation was given to the order of this court, causing immense prejudice, causing legal prejudice to the petitioner, whereby his valuable right of a fair consideration has been infringed. Full stop. Para. The learned counsel for the petitioner also submits that subsequently, for the same location, another advertisement has been issued on 25/10/2014. Full stop. However, the category was changed from open inverted comma to settled caste. Full stop. It is submitted that in view of such change of category comma, the right of the petitioner to participate has also been adversely affected. Full stop. Sri Chakraborty accordingly prays for an appropriate order by which justice would be done to the aggrieved persons. Full stop. Para. Sri Bharadwaj, the learned standing counsel of the corporation, however, submits on instruction that since the institution of the case, comma, there has been various changes in the guidelines for allotment, and the entire mode of allotment is now done by draw of lots to remove the element of any bias or lack of transparency. Full stop. He submits that in view of the aforesaid development and elapse of a considerable period of time of about a decade, comma, the corporation is contemplating even to cancel the second advertisement dated 25/10/2014. Full stop. He further submits that the aforesaid contention was already made in another writ petition instituted by one Arun Kumar Singh, which was, however, dismissed for default. Full stop. Para. In view of the aforesaid facts and circumstances, comma, this court is of the view that interest of justice would be served if the corporation is served that instead of going to the issue raised in the present writ petition, comma, the corporation be allowed to initiate a fresh process for allotment of the retail outlet of the KSK retail outlet at the concerned location by cancelling the second advertisement dated 25/10/2014. Full stop. Sri Bharadwaj further clarifies that so far as the change of category is concerned, comma, the same depends on the existing roster and the petitioner may not even have any grievance if, as per roster, the location is declared to be under the open category. Full stop. In any case, comma, this court is of the opinion that the petitioner would have the liberty to approach this court in case of any grievance with regard to any advertisement that may be published after cancellation of the advertisement dated 25/10/2014, which is under contemplation of the corporation. Full stop. Para. Writ petition accordingly stands with the aforesaid directions and observations, comma, writ petition accordingly stands disposed of.
Okay.
Mayor, please. My lord, in this matter, my lord, page number 36. This is the order initially which I was telling. This is the order which has been passed by Northeastern Front Railway, which says that I'm not eligible to continue with the apprenticeship that I was continuing with the railway office. on the ground saying that since I don't possess the ITI certificate, my lord, by dated 1/11/2016, there was an interim protection which was given to me. At that point of time, there was an examination of the apprenticeship. This honorable court has directed and allowed me to appear in the examination, but my result will not be declared. It will be subject of the outcome of the writ petition. Now, right now, my lord, in the meanwhile, they have also submitted their affidavit. Now, question that has been raised, my lord, regarding the certificate that I possess. My lord, may kindly see the certificate that I possess.
Now, what about the results, Mr. D? No, you have it in seal cover or what?
Yeah.
Can you open it?
Unless it's port water lordship,
No, can you open it? We'd like to have a look.
that's not we just thought.
You should have got it. If he has qualified in the,
No, this is not case thought. Whatever his result, whether he fails or pass or fail, that is separate thing lordship. Case is not eligible because he has not submitted his proper certificate. ITI certificate he never submitted. So that is why authority has cancelled his candidature.
he is not eligible as per you.
Not. As per our advertisement.
Then whether he passes or fails in the examination, that will not be of consideration
No,
because he is not eligible.
Yes, since he's not eligible.
Maybe the court thought that if he is held to be eligible, then he should not be deprived of
No,
sitting in the
if he
examination.
pass, then he will be eligible.
But the precondition is that he should be held to be eligible.
Lot.
Now we are on the issue whether he is eligible or not in
Exactly
essence of an ITI certificate.
Lot. This
Okay.
is the case.
Okay. Yes.
My lord, I will request your lordship to come to the advertisement. Start with page number 15.
1-5.
1/5, my lord.
Why two cases?
My lord, I think it is similarly.
Similarly placed.
But my lord, I'm not appearing on that. matter,
Doesn't
so
matter.
I have no idea.
You are in which one?
I'm in the item 10.
Uh,
Jayanto Gogoi.
Jayanto Gogoi. Yes.
Yes.
Which page you want to
My
refer?
lord, page number 15 is the advertisement.
1-5.
1/5.
What is the date? Date.
My lord, 17/10/2014.
No, this is the opening date. What is the date of this? Mr. Day, what is the date? Okay, let us take 1710. Doesn't matter.
My lord, page number 19 is the relevant portion that I'm trying to stop.
This is advertisement for what? This is advertisement by
Engagement
by the railways,
Yes,
NF
ma'am.
Railway.
Office of the Chief Workshop Manager.
Engagement, where serial number?
My lord, at the top, the Office of the Chief Workshop
Yes,
Manager.
that is okay. You're interested in which post?
Yes, ma'am. I'm referring to
For
the
engagement
welder.
of,
Point number 2, my lord.
and for engagement of ITI passed out candidate.
Yeah.
Candidate. Yes. Serial number?
My lord, number 2 in the box, that is welder.
Okay.
That is the trade I have applied for.
Serial number 4. Serial number 2 in the, okay, serial number 2. Welder.
Yes.
You applied for welder?
I applied for. My lord, there are certain conditions which has been placed here.
Yes.
My lord, may kindly come to page number 19.
19.
19.
Are you an ITI passed out candidate?
My lord, there is a confusion with this regard. The certificate that I possess, I consider it to be an ITI.
Let us see that certificate.
Page number 14, ma'am.
14.
14. The National Council for Vocational Training, National Certificate in Modular Employable Skills.
National Council, what is this?
It is issued by the Ministry of Labor and Employment, my lord.
National Council
For
for
vocational training.
Training. Jayanta Gogoi. Your past what competency is in what? Gas cutting,
Yes, my lord.
fabrication. Okay. You say this is equivalent to an ITI certificate.
Why am, my lord, that I will subsequently place it before your lord.
Yes,
My lord, may kindly come to page number 19.
19. Yes.
One. This says, my lord,
19. Yes.
19. The applications having any
Mr.
of the
Agarwala, you can come, which matter? That yesterday's matter. You can come after some time. This will take at least 15-20 minutes. You can come at 2 also, no problem. It will take at least 15-20 minutes, this matter.
My 30.
Okay. Page 19.
page
yes.
19. The heading says, my lord, the applications having any of the following deficiencies, discrepancies, or irregularities will be summarily rejected.
Yes.
My lord, there are many conditions that they have placed, the eligibility criteria, the education, and everything. And along with it comes the heading which says summarily when my application can be rejected.
Yes.
Point number 8, I will straight away refer to, my lord.
Yes. Yes.
Not having the requisite educational qualification at the time of submitting the application.
Yes.
Now, when I have submitted this, I have considered my certificate to be an ITI certificate,
Yes.
and my lord, accordingly, I have applied it. Now, there is a specific clause in their advertisement itself, which says that summarily when it will be rejected. Now, once I submit this application, point number 8, if at all what they are placing today, if that is the case, then point number 8 will come into existence, and my application should have been rejected at that point of time. Now, referring to page number 20, my lord.
20.
20.
Yes. What happened?
This is the to the Jayanta Gogoi. It has been issued from the office of the Chief Workshop Manager, Mechanical Workshop Dibrugarh, the institute under which I'm going to have my apprenticeship.
Yes.
It is referred as, my lord, call letter for document verification and medical examination of passed out ITI candidates declared successful in the screening for engagement as ACT apprentice in NF Railway Mechanical Workshop Dibrugarh under the Apprenticeship Act and Apprenticeship Rule, which says that, my lord, there was a screening of documents. There I was found fit. As a result, they have called me for verification. By what verification, my lord? The documents that I have submitted, that was in Xerox. Now I have to bring the documents in original. Now here it has referred, dear candidate, after screening, you are found suitable and selected for engagement as ACT apprentice in welding trade. You are hereby advised to attend at NF Railway Mechanical Workshop Dibrugarh on 2/9/2015 for document verification and medical examination.
Okay.
This says that the documents which I have submitted and the condition number 8 in the advertisement itself says that yes, I am the one who is eligible and my certificate is considered as ITI till now. After that, my lord, page number 22.
22.
2.
Yes, please.
This is the letter from the office of the Chief Workshop Manager itself to the principal, which says that the following selected ITI pass candidate of an ACT apprentice of DBWS was directed to report at your end for undergoing apprenticeship training, and their durations of training period are shown as under. Their actual date of joining of apprentice, my lord, serial number 15.
Yes.
After document verification, they have found me suitable. Medical examination, they have found me suitable. Now they are sending this letter to the principal. Serial number 15 is my name,
Yes,
Jayanto Gogoi,
yes, please.
as welder, and the duration of training was 1 year.
Yes,
Now till now, my lord, my selection and admission in the college, they have considered my case fit and proper. My lord, page number 29.
29. What is 29?
Page number 29 is a letter which was sent to me to submit the ITI mark sheet. As directed by the Regional Director of Apprenticeship Training, Geo Complex, so you are advised to submit the ITI mark sheet within 15 days of receipt of this letter. It would not be out of place to mention here that at time of application for apprenticeship training in Emirates Railway, you have claimed to have passed ITI course and has enclosed a certificate. The same was sent to Regional Director of Apprenticeship Training for registration of contract under Apprenticeship Act. The RDAT has returned the contract with remark that ITI passed NCVT marksheet certificate not attached. It means that at that stage, when they were preparing the contract, they found that I don't have this ITI certificate. But on the other hand, when the entire process continues, they have considered my case, thinking me to be a passed out candidate of ITI.
Okay.
Page number 30, my lord.
30, yes.
Here, this is an application which was sent by me to the Superintendent Industrial Training Institute, ITI Dibrugarh. This is the institute from where I have obtained this particular certificate.
Yes.
Application for issuance of ITI marksheet against certificate number 20. Respected sir, with reference to the subject cited above, I, Sri Jayanto Gogoi, completed 3 months ITI course from your institute in the year 2013. I had also got my certificate with following numbers against this particular course, and same was submitted and verified at the time of application in apprenticeship training in NF Railway Dibrugarh, Assam. I also selected for apprentice training, but after 9 months of training, they demanded to produce my ITI mark sheet. So I am requesting you to
Okay,
kindly.
we have read.
Yes. Accordingly, my lord, there was a reply given to me from the superintendent of ITI Dibrugarh. Having reference to the above matter, I would like to inform you that as per the guidelines provided by DGET New Delhi, candidates trained and assessed for MES course modules under SDIS are issued only proficiency certificate by so and so under so. There is no provision for issuing mark sheet under this scheme as stated by the RDAT. My lord, accordingly, this was the communication which was going on, my lord, between the superintendent of the ITI institute from where I have passed. My lord, there is, I refer to page number 32, my lord.
Yes.
This was the information which was given by me to the Chief Workshop Manager, Assistant Personnel Officer, NF Railway Dibrugarh, regarding the communication between me and the superintendent. My lord, page number 33, that aspect, my lord.
Yes, 33.
Page number 33. This is from the superintendent, ITI Dibrugarh. To the Regional Director, Apprenticeship Training, ER Kolkata. Difficulties in apprenticeship training of trainees passed under MES scheme conducted by RDAT. Having reference to the above subject, I have the honor to inform you that one student of our institute, namely Sri Jayanto Gogoi, passed MES course in welding trade under RDAT, and got certificate of NCVT. Then he took admission into the apprenticeship training under NF Railway Mechanical Workshop, Dibrugarh, Assam. But after 9 months of training, the authority demanded marksheet. But in MES course, marksheet is not issued. It is worth mentioning that the whole training process is conducted by RDAT.
Yes.
My lord, the RDAT is the Regional Director of Apprenticeship Training Eastern Region. RDAT and DGET New Delhi, and certificate without marksheet is also provided by RDAT Kolkata. Sir, MES is a central government scheme and certificate is provided by NCVT and RDAT. At the time of admission into NF Railway Apprenticeship Training, the certificate of Sri Jayanta Gogoi was verified and allowed to take admission into apprenticeship training. The boy has completed about 9 months of training, and after that, the NF Railway Authority has demanded the marksheet. If a certificate issued by DRDAT itself is not suitable for any apprenticeship training under RDAT, the scheme will not be any more beneficial for any training. Moreover, RDAT as well as DGET New Delhi have continuously pressurizing us for the placement of those trainees passed under this scheme. Third, the matter may be treated as most urgent and kindly allow Sri Jayanta Gogoi for registration and also to appear in the final examination of apprenticeship training. My lord, the scheme is made by the authority and accordingly the ITI Institute executes those schemes. Under those schemes, I have underwent a training and I have completed that training. Once I take up the certificate, I bring it in front of the authority, they select it, they scrutinize the document, and since my duration is
Thereafter,
12
what has happened?
then my lord, on the 9 month, the duration of my training is 12 months. On the 9th month, they are asking me the mark sheet.
No, that is okay. Now what has happened?
Now, my lord, since I have been allowed to give the examination, I have appeared in the exam. Now, what remains is the mark sheet. Whether I have passed or failed, I am unaware. And since I have been protected by the interim of the court,
Examination of what?
my lord, the examination of this ITI apprenticeship training, at the end, completion of the course, we have to give the examination. And that examination, I have appeared.
Okay. Okay.
That is my.
Yes, Mr. Dev.
But who could file the FPT? Or FPT sheet. First of all, I'm coming to the petition. That is in advertisement. Page number 15.
15.
15. Page number 15.
Yes. Yes.
The welder lot, if the applicant has applied for the welder, that is true, already my learned friend has submitted. And that should be the 1 year course, not the ITI course. ITI certificate should be 1 year.
Yes.
But the applicant submitted the ITI certificate notice. It is a diploma course, only 3 months course of 3 months course certificate, NCVT. It is not ITI certificate. Because ITI certificate, which is issued by RDAT, Calcutta, when the local authority, our NF Railway, and send it to Calcutta, then it is only verified and it is found that this is not a ITI certificate. On that ground, Lordship, the candidature of the applicant has been cancelled, Lordship. and it has been communicated, and
That is a 3 months diploma.
yes, 3 months diploma. But in the advertisement, it is required 1 year certificate, Lordship, 1 year courses certificate, ITI certificate.
Yes.
But while it is found, Lordship, in Calcutta, this is not a 1 year, but several times has given the applicant to produce the ITI certificate. But it failed to produce, Lordship. Then only, Lordship, the impugn letter was issued that his candidature has been cancelled, as because he has not submitted the proper certificate, qualification.
Where is the impute order?
Page 36, my lord.
Page 36, so
36.
36. 36 and 37.
Hmm. Yes.
This is the 36 Lordship page number for the principal assistant. In view of the observation made by RD80 Kolkata, I their letter number so and so, dated 31/5/2016, you do not possess ITI certificate mean for the recruitment of Act Apprentice height notification number 1/2014 DBWS dated 17/10/2014. Accordingly, the CWE NFR has approved your termination from the apprenticeship training, and your apprenticeship training is terminated with effect from 28/2016. You are advised to deposit the training cost of an amount equivalent to your 3 months last bronze stipend as per rule so and so. When department, even authority asks for the stipend also, because already 3 months stipend he has taken. While it is examined in the Calcutta Lordship, as per the certificate number, it is found that the certificate is not a ITI certificate. Even Lordship, for this clarification on the last occasion, the Honorable High Court has directed CGSC to confirm this, whether it is true or false. And according to CGSC has filed also affidavit and confirming that this certificate is not a ITI certificate. Lordship, in our affidavit, in our affidavit in page number 10, the Lordship circular for this. And the welder, it is required 1 year. 1 year. Page number 11.
Page number 11 of
Affidavit.
your affidavit.
By page number 10 and
Paragraph.
page number 10 and
A paragraph.
11 portion is 11, serial number 15, Lordship.
Paragraph number 15.
Serial number, Lordship.
Which page are you referring to?
It's affidavit page number 11, Lordship. Affidavit by me, Lordship.
Utpal Sharma.
Joint to Gogoi, yes.
Utpal Sharma is the
Yes.
deponent Utpal Sharma.
Yes, Utpal Sharma.
Which page? Page.
Page 11, Lordship. 10 and 11. Connector A, Lord.
Yes, just a minute, please. Yes, 10, what is this?
Page number 10 and 11 portion is page number 11, Lordship. 11, serial number 15, welder, within bracket gas and electric. The training courses period is 1 year.
That you have mentioned in your affidavit also,
Yes, yes.
in the advertisement
yes,
also.
Yes, yes, sir. It is there also. It is there also. Now, Lordship, the RDAT has sent letter to the local authority.
Yes, what do you want to show?
And the annexure number, Lordship, kindly find is number 12, annexure P,
Hmm.
subject forwarding contract proposal after registration. Reference so-and-so, in person so-and-so, referred above, please sign and close. 2 copies of contract proposal. 23 numbers of apprentices are forwarded herewith after registration. The remaining 4 numbers apprentices of these as contract form are following deficient. Number 1, Jayanto Gogoi, is the petitioner Lordship, and Sanjeev Parla, and so. The above serial number 1 and 2 are not attached. ITI pass, NCVT, SCVT marksheet certificate, optic certificate. And serial number 3 is SCVT certificate of period of training as per so and as well. Serial number 4 is already issued state NEC certificate. So return the 4 numbers of contract form for rectification. So you are requested to please resubmit the contract proposal. This is the given the opportunity for giving the, and then annexure C lot. Accordingly, it is informed the joint petitioner lot.
Page,
Case 13 lot.
this is to Sanjeev Barla, not to the petitioner.
This is my affidavit.
No, this is to the one Sanjeev Barla. What is your
No,
name?
these two, three Jayanto Gogoi.
This is 14, item 4, series 14.
13.
Page 14.
Page 14 lot.
13 is to Sanjeev, this Sanjeev Barla.
Oh, yes. Yes, Lord.
16.6.
And is there by the regional director and apprentice training year, CEO complex, E block sector so-and-so, Salt Lake, Kolkata so-and-so, you are advised to submit the ITI mark sheet within 15 days. It would not be out of place to mention here that at the time of application for apprentice training in NFL, you have claimed to have a pass ITI course and has enclosed a certificate number so-and-so. The same was sent to the regional director of apprentice training year for registration of contract under Apprenticeship Act 1961. The RDAT year has returned the contract with remarks that ITI pass NCVT, SCVT marksheet certificate not attached. Accordingly, you are advised to please submit the ITI pass NCVT, SCVT certificate within 15 days to receipt of letter positively. Otherwise, action will be initiated to terminate your training as apprentice.
Yes. Yes.
Annexed T lordship.
Page 15.
15 lot.
Yes.
In terms of PM, MLD and RDAT Kolkata, letter under reference survey report. This is the survey report not. Meaning plot of apprentice in CSWS has been done by CRR Delhi Assistant Central Apprentice Advisor, registered so-and-so Kolkata, DBS on 8/3/2011 and 9/3/2011, and the report signed by the administration and apprenticeship advisor are sent herewith for your kind information and necessary action.
How is this relevant? Page 15. The letter which you have just read,
Yes,
page
yes, yes.
15, 5/4,
Yes, Lord.
2011, how is it relevant?
Yes. My lord, my statement, lordship. It's page number 4.
Now, how is it relevant to the issue? What is the connection of this?
Because, lordship, this certificate was for sending for examination. And for examine for that, the 2 person was appointed to examine the certificate. Whether it is a correct or not, whether it is a 1-year ITI certificate or not. Survey. This is the survey report, lordship.
Not very relevant. Then what has happened? So what about the Mr. Dey, what about the contention that he wrote to the authorities to give the mark sheet? They said that we cannot give mark sheet. See, your contention is on a different footing, that the course which he has undergone is a diploma course of 3 months. That will not be sufficient for the present job in question. And therefore, and that you have stated now that earlier you had shortlisted him, allowed him to join, he was continuing. Then later on you said that we want your mark sheet. He tried to get his mark sheet. Mark sheets are not available because it was not issued. Now, it's a different matter altogether, whether you have taken the grounds that his course was not of 1 year. So therefore he is not eligible to be considered. But that does not come from the documents. Which document have you said that your course?
The certificate enclosed, lordship. This certificate enclosed, when it is examined in Calcutta, with this number, it is found that it is not a 1-year course certificate.
Where have you stated?
Lordship.
Where have you stated this?
This is in my, it is also.
Let him finish.
Yes,
Let him finish. We'll come to you.
Yes.
Okay, welcome.
That is pair number 4, Lord.
Of your affidavit?
Yes, sir. Page number 4.
Yes, please.
Before that, I'm coming to the page number, same page, pair number 3.
Hmm.
That with respect to the statement made in para 3 of the petition, under reply, it is stated that the application are invited in the prescribed format, the candidates fulfilling candidates of the chief workshop manager and NFLO, mechanical workshop Dibrugarh, notification so-and-so, dated so-and-so for engagement of 43 numbers of Act Apprentice NFLO, mechanical workshop Dibrugarh under the Apprenticeship Act 1961 and Apprenticeship Rule 1962 for imperative training. It was inter alia laid down that in sub-para 5 of para 12 of such notification, annexed 2 of the writ petition, that before applying, the candidate should ensure that she fulfills the eligibility and other criteria. At any stage of engagement, if erroneously engaged, such candidate shall be summarily dismissed without notice. In terms of this office notification IPI, the qualification was matriculation within bracket of 10 plus 10 class in 10+2 examination system, and having ITI certificate affiliated to NCVT compulsorily in relevant trade, annexed 2 of the writ petition. Despite of clear instructions, the petitioner falsely declared and erroneously engaged. Next parallel. That with respect to the statement made in para 4 of the writ petition, under reply it is stated that it is admitted to the extent supported by record. Moreover, it is imperative to mention here that in view of the observation made by RDAT, Kolkata, ITI letter number so-and-so, dated 31/5/2016, very important law, wherein under 4 cases were referred along with petitioner of writ petition number so and so cases of the Sandeep Pala and the Jayanto Gogoi examined and found that they do not possess ITI certificate meant for recruitment of Act Apprentice by notification number so and so dated 17/10/2014. The application were given ample opportunity to produce the ITI certificate which has been claimed by them in their application for Act Apprentice in pursuance of this office notification dated 17/10/2014. At this office letter number so and so, apprentice DBWS dated 16/6/2016, but they failed to do same. Accordingly, in terms of condition laid in the notification on being established that the applicant, though not possess ITI certificate in relevant date, nor certificate issued by ITI, is under the aegis of National Council for Vocational Training Scheme towards craftsman training scheme got selected and undergoing training at SPC NVQ terminated from the training. In pursuance
Mr.
of
Dev, we have read the affidavit. You have not stated anywhere that your requirement is for an 1 year course and he has done 3 years
no,
diploma.
it is in my lordship in my annexure it is given annexure A.
Where?
Annexure A, page number 10 and relevant page is 11.
No, this is your guidelines.
Yes,
Where is the
Lordship.
statement?
Yes.
That his course is not of 1 year but 3 months. That is the basic statement you have to make in your defense. That he has produced a
No,
certificate.
But in the advertisement, what it is stated, lordship, in the advertisement also that lordship, in the 1 year.
Are we disputing that the requirement is 1 year? We are not disputing.
Lord.
Where is your statement? It has not meet the requirement of 1 year.
No, lordship, it stated, no, lordship.
Where? Show us. Entire affidavit you have stated nothing. Requirement is 10 years, requirement is 1 year. Okay, we agree.
Yes.
And you have to make a simple statement that his certificate is for 3 months. Diploma. You have already submitted. Where is the statement? Where is the document? Verification from that authority that is a 3 years diploma course he has undertaken.
No, that we have not given, lordship.
Then where is the statement that is, you have to reject on a ground which is acceptable, reliable, cogent, acceptable.
But impugned letter is there, lord.
Where is the impugned letter? Impugned letter is simply said you do not meet the requirement. Where is the statement? You have in the affidavit you have to state that is a diploma course of 3 months. He is not eligible.
No, that is the report, lordship, sent by the Calcutta. That is only the.
Where? Show us. Instead of writing lines after pages, 1 line is required that this is his certificate, this is for 3 months. We require 1 year. Matter ends there.
Yes, it is lordship, kindly peruse page number 12, annexure P.
Page number 12.
Yes,
Yes, what is this? Yes,
it's sent to the.
yes,
letter.
what is there?
This Jayanto Gogoi's name is there. That is.
Jointo Gogoi, yes, Jointo Gogoi is at 2. Serial numbers 1 and 2 have not attached ITI pass certificate.
Yes.
That is your reason.
Yes.
He cannot possess ITI certificate. He wrote to the authority. They said we do not give mark sheet. That is a different aspect altogether. You're on a different footing that the paper document which is relying upon that it pertains to a 3 months course. We need 1 year course. Matter ends there. We have not stated anywhere. You find if there is any statement or any document by which he was informed that this certificate of yours is a 3 months course, which is not as in terms of the advertisement, neither the requirement in law. Page 10 says 1 year, advertisement says 1 year. Your certificate is for 3 months. You have not stated anywhere. You're only asking for ITI mark sheet and that too after sufficient time.
Mark sheet or and certificate. Oblique certificate.
That is it, but
Yes.
you did not reject him initially. We'll not say that later on you cannot correct. You can, but you have to be specific. Yes, this document is not a document which we require for an apprentice. He has to acquire, possess a training course of 1 year, which he has not done.
My lord, if lordship may allow.
Mr. Goswami, what have you stated anything in your affidavit? Hmm?
In terms of the order, 4/4/2022, and affidavit has been filed by the respondent number 10.
Yes. What have you stated?
That, paragraph 3 onwards of the affidavit.
You have made something, said something in paragraph 6,
No,
internal base 3.
no.
Please read.
Demonstrate that the certificate number so and so, dated 2/8/2013, with so and so number. Stood in favor of the joint Gogoi for undergoing training on a module named the gas cutting. ME's course, code number so and so, is a course of 120 hours duration, 15 days duration. The minimum education qualification required at center. Likewise, in paragraph 7, it creates to take petitioner. Same malad. Paragraph 8, as per the Schedule 1 of the Apprentice Rule 1992, designation paid welder of duration 1 year, 3 months. The qualification for being engaged as an apprentice is as follows below. First, its standard examination from a recognized school. In this case,
Yes, sir.
your apprentice
Yes,
will be
yes. Yes, how do you meet this? Railway have not stated anything. Railway's defense is no defense. Central government has said something that your course is of a duration of 120 hours, that is 15 days, which does not fit into the requirement of 1 year, so far as welder is concerned. How do you overcome this?
My lord, may kindly come to page number 15, again the advertisement part.
Yes.
If I can understand properly, my lord, the point number 4, which describe this period, it says the apprenticeship will be engaged in the following trade, and selected candidates will have to undergo training. Principal Supervisor Training Center, New Bongaigaon. The heading says name of trade. Then if I come period of training, period of training is 2 years. Rebate allowed to apprenticeship training to ITI candidate is a rebate, a discount. That is 1 year. The duration is 2 years.
Yes.
Discount is 1 year.
So remaining balance is 1 year.
No, yes, but
You have
my
done a
lord,
15-day course.
my lord, as far as I understand, my lord, they are referring to this particular apprenticeship that I am going to do it.
Now, what is the eligibility? How do you get into the job? Job means the job of the apprentice.
Yes.
How do you get into it? They have prescribed a minimum requirement.
Yes, madam. They have mentioned it. The qualification part is there.
And Mr. Day in his affidavit paragraph, page 10, the rules have been quoted, which requires one year. Have you stated anywhere that you have done a 1 year course?
My lord,
We'll come back at 2.
Sorry, would my lords please permit me to mention? Sorry, my lord, Mr. Shah.
Yes. Anything?
My lord, I'm in serial number 8, my lord. May I request if I could have a short adjournment in that? I have some personal difficulty in the second half.
Serial number 8. What is this
Yes,
matter?
My lords, this is a service tax matter where the impugned order had been passed contrary to the board's direction and a
Who's for
Supreme
the,
Court.
My lord, I have informed my lord over telephone, STKL, my lord, STKL.
you're assisting Mr. Kyle?
Yes.
Some accommodation has been sought for.
My lords could take it next week, please. Next Thursday.
Next Thursday would be,
The
21st.
21st.
21st. We can try on 21st.
Very well. And my lords, there were interim orders, including my lords from.
Okay, we'll have it on
July
21st.
22. Yeah.
Sri
And the
R.
interim
Shah,
orders.
Learned Counsel, who has appeared online, has paid for a short accommodation. Full stop. The, your madam, your name?
Zero.
MSc Royal Learned Council has appeared on behalf of Sri S.C. Kyle, Learned Standing Council, GST, CGST, full stop, para, as agreed to by the Learned Council for the parties list on 21/3/2024, full stop, interim order passed earlier to continue till the next date of listing.
Deeply obliged.
I'm very grateful to you.
Please.
Regarding the tenure of consideration of 1 year. My lord, as per the advertisement which has been referred to. My lord, page number 15.
Yes.
My lord, it says about this point number 2, my lord, welder. Period of training, my lord. The entire course of period of training for apprenticeship is 2 years. The rebate allowed to apprenticeship training to ITI candidate. It is the rebate. If somebody has done their ITI, then this 2 years apprenticeship will be for 1 year. It is not a condition that says that 1 year ITI should be done by me. It is a rebate. Once we have devoted that particular period of time, accordingly, this particular period will be given to you, 1 year period. This is what my understanding goes by. It doesn't say anything about this particular part that there should be a 1 year course that you have undergone. And if I consider the affidavit, my lord.
But the initial condition.
Yes.
Which finds place in page 15. Engagement of passed out, the first line itself.
Yes.
Engagement of passed out ITI candidates. So
Yes,
that
sir.
condition you have to fulfill.
Yes, ma'am. My lord, the problem that happened with me is that since the institute under which I was going the training was an ITI.
Was it an ITI institute?
ITI institute. The ITI institute, because my lord, the superintendent, lordship may kindly come to page number 33.
Yes.
He is the superintendent of ITI Dibrugarh.
Yes.
He refers here that having reference to the above subject, I have the honor to inform you that one student of our institute,
Yes.
our institute, the ITI, Industrial Training Institute of Dibrugarh, namely Sri Jayanto Gogoi, MES course in welding trade under RDAT and got a certificate of NCVT. Then he took admission into an apprenticeship training under NF Railway Mechanical Workshop. But after 9 months of his training, the authority demanded marksheet. But in MES course, marksheet is not issued. This says that I was under the ITI Institute. They are the one, he is referring as my student. My lord, after obtaining that certificate, I am of the impression that this is my ITI. It may be under any scheme. This is a central scheme or state scheme, my lord, that is secondary. But as soon as I give the application, My lord,
Just a
page
minute.
number 16.
Just a minute. Mr. They in your paragraph, in your affidavit in opposition, how have you replied to paragraph 6 of the writ petition? Come to first page 7 of the writ petition. Page 7, paragraph 6. Please read.
That the petitioner states that the appointed ITI Dibrugarh filed his letter dated 28/2016 has also informed the respondent number 2 that MES is a central government scheme and certificate is provided by National Council for Professional Training NCVT and Regional Director of Apprentice Training RDAT. It was also informed that at the time of admission of the petitioner into NFL apprenticeship training, his certificate annexure 1 was verified and after being accepted was allowed to take admission for training and has already completed 9 months of training at the time of issuance of the said letter, and if the said certificate is not suitable or accepted, the said scheme will be fruitfulness and thereby requested for allow registration of the petitioner and also to allow
Your reply is at page, reply at internal page 6 of your affidavit in opposition. Paragraph 5.
that respect to the statement which paragraph
There is no reply as such.
that certificate truth of certificate came into notice of administration after audit.
Mr. Biswakarma, you have not overcome the averments made by the Union of India in paragraph 6. You have not even filed any reply.
Oh.
That is, yours was a 120 hours duration course.
My lord, actually, this brief was earlier deal with.
No,
Mr.
but this is a very specific statement. Your
Yes, my lord.
certificate has been verified.
Yes.
It turns out to be a course of 120 hours. Maybe the ITI Dibrugarh has said that you were a student. What course you are undertaking, that is not clear.
Not clear.
And you being a student of ITI Dibrugarh, as per that letter, you were sent for, you had undergone that course in Kolkata. And that was for 120 hours. This is something which is a stumbling block in your.
My lord, actually, till now, I have not received that. That's why I'm not able to. Maybe the conducting council who was dealing with the case earlier, my lord, he might have the copy, but I don't have it with me. That's why I cannot find any.
But he has also raised one of the point that the training is for 2 years, and in case you have had a course, you have a rebate for 1 year. Where is the requirement of a minimum 1 year course? That to be eligible to be inducted as an apprentice under the railways, you need to have a 1 year course under the ITI. Where is the requirement? The advertisement, which has been annexed to the writ petition at page 15. You have just said that engagement of passed out ITI candidates.
Hmm.
You have not said what should be the duration of the course undertaken. And so far as the table is concerned,
Yes.
you said apprentices will be engaged in the following trades and selected candidates will have to undergo training. Also for so and so. This, what is the training period? For a welder, it is 2 years.
Yes.
And if he has already had a training in the ITI, then he gets a rebate of 1 year.
Two lots. But he's not done the ITI. certificate.
No, but that mark sheet was never issued. It was not there. He had tried.
But it is a 15 days course, there is a no mark sheet not. That is why they have not given the mark sheet. 15 days course, how mark sheet will be provided? This is the cause behind it.
That,
If it is a 1 year course, then he will got the mark sheet not.
that plea you have not taken, unfortunately. It's a matter of coincidence that, or maybe another opportunity, that much later the union has taken the plea. Okay.
Okay.
My lord, that aspect of the matter, my lord, that 15-day course. My lord, I'm unaware whether it's 6 months course or 15 days course, because even that is silent in the writ petition.
No, it's stated on affidavit that certificate was verified.
Yeah.
Otherwise, had it been by some private individual interstate dispute, then probably would have still given you a chance. Okay, heard. Sri K. Biswakarma,
Yes, my lord.
learned counsel. For the petitioner. Also heard Sri D. Day, D.K. Day, learned counsel representing the NF Railways, as well as Sri U.K. Goswami, learned CGC. Mr. Sharma, you are also there? No. Full stop. Para. The facts projected in the writ petition is that the petitioner had passed the competency test in modular gas cutting under sector fabrication welder from the Industrial Training Institute within bracket ITI Dibrugarh, and was provided by a certificate issued by the regional director, regional directorate of apprenticeship training within bracket RDAT on behalf of the National Council for Vocational Training within bracket NCVT bracket close Eastern Region Kolkata. Full stop. Pursuant to an employment notice dated 17/10/2014, whereby applications for engagement of passed out ITI candidates as ACT apprenticeship, A capital, in in various trade, including the trade of welder in NF Railway Mechanical Workshop, Dibrugarh, the petitioner had offered his candidature. Full stop. It is the case of the petitioner that, have your seat, after verification of the documents and medical examination, he was selected for undergoing the training, which was for a year wide, letter dated 29/10/2015. Full stop. The petitioner had reported to the STC, Bongaigaon, for undergoing the said training. Full stop. After completion of 9 months of training, a letter was issued on 16/6/2016 directing the petitioner to submit the ITI mark sheet within 15 days. Full stop. It is the case of the petitioner that he had already submitted the ITI certificate initially. Full stop. Nonetheless, the petitioner had made an application on 26/2016 requesting the superintendent of ITI to issue the mark sheet. Full stop. However, vide a reply dated 24/6/2016, it was informed that only proficiency certificate were issued and there is no provision for issuing mark sheet. Full stop. The said communication dated 24/6/2016 was brought to the notice of the authorities. Full stop. However, vide the impugned order dated 13/8/2016, the petitioner was terminated from the engagement as apprentice, which he had completed which he had completed about 11 months. Full stop. As a result thereof, the petitioner was deprived from appearing in the final examination.
It will be 9. Completed almost 9 months.
That is his projection. Deprived of appearing in the final examination, which was to be held in October 2016. Full stop. The petitioner was also advised to deposit the training cost, which was equated to be 3 months of last drawn stipend. Full stop. Para. 3. Vishwakarma, the learned counsel for the petitioner, has submitted that the certificate obtained by him dated 2/8/2013 is equivalent to an ITI certificate. Full stop. By referring to the advertisement, comma, he has submitted that there are certain clauses under which an application could be summarily rejected, and one of such clause was not having the educational qualification. Full stop. He submits that in spite of existence of such clause, comma, not only the candidature of the petitioner was accepted, comma, he was also inducted for the apprenticeship course and was sent to Bongaigaon. Full stop. He submits that by the conduct of the respondents, comma, there was no manner of doubt that no questions were raised on the eligibility of the petitioner. Full stop. Para, by referring to the communication issued by the ITI Dibrugarh, comma, the Learned Council has submitted that the petitioner has been termed to be a student of the said ITI, and therefore the issue on which the impugned action has been taken is without any basis. Full stop. In this regard, comma, reference has been made to the communication dated 26/2016 by the ITI Dibrugarh to the regional director, to the regional directorate of apprenticeship training within bracket Eastern region. Full stop. The Learned Council has also drawn the attention of this court to the order dated 4/10/2016 and 1/11/2016 passed by this court. Full stop. By the first order dated 4/10/2016, comma, it was observed that the petitioner may not refund back the last 3 months stipend, and by the subsequent order dated 1/11/2016, comma, the petitioner was allowed to appear in the All India Trade Test of Apprentice, which was commencing from 8/11/2016. Full stop. The Learned Council submits that pursuant to the aforesaid order, comma, the petitioner had appeared in the test, and as per observation made by this court, comma, the results have not been declared. Full stop. Para. Sri Vishwakarma accordingly submits that interference is required from this court for by which the petitioner may not be held to be ineligible for the apprenticeship course, the major part of which was already completed by him. Full stop. He further submits that since the petitioner had also appeared in the final test, comma, the results may be allowed to be declared depending upon which consequential steps be taken. Full stop para. Per contra, comma, 3D, the learned counsel representing the railways has submitted that the initial action of the respondents in shortlisting the petitioner and sending him to the training at Bongaigaon will not preclude the authorities from scrutinizing the documents. Full stop. He submits that full opportunity was granted to the petitioner to produce the relevant documents, which includes the mark sheet from the concerned ITI, which he had failed to do. Full stop. He submits that the certificate of the petitioner dated 2/8/2013 cannot be held to be equivalent to an ITI certificate which is required by the advertisement dated 17/10/2014. Full stop para. They has also referred to the RBE number 74/95 on the subject of recognition of educational qualification dash certificate issued by the National Council for Vocational Training dash equivalent to ITI. Full stop. He submits that in the list of trades, comma, again serial number 15, comma, welder, the trade of welder has been stated, which requires a training period of 1 year, which envisages, not required, which envisages a training period of 1 year. Full stop. Para. The affidavit, however, affidavit dated 14/2/2017 of the railways, however, does not specify the exact reason, specify that the course undertaken by the petitioner was not of the specified duration. Full stop.
It is document page number 3.
Where's,
Page number 3. Last page. My epic.
yes,
In terms of the railway board number so dated so welder trade pointed training are implemented under the and 6 months national site between this petitioner was erroneously engaged and started.
you said 6 months.
Yes, they have stated 6 months. That is why we stated. But after central government inquiry, it is found that it is a 15 days.
Okay, well, no, okay. Last problem not likhe. Sri Day has also referred to the averments made in paragraph 2 of the affidavit in opposition dated 14/2/2017, wherein it has been stated that the certificate of the petitioner is of 6 months, whereas the requirement, where is the 1 year requirement stated? Not stated.
Welder trade with 1 year trade.
Where?
In terms of railway board circular dated.
Okay, where is the requirement as per the railway board circular dated 26/7/2000 at 1995 for welder trade, 1 year training period is required. Full stop. Para. Supporting the stand of the railways, Sri Goswami, the done at CGC, has referred to the affidavit in opposition filed by the respondent number 10 on 17/6/2022. Full stop. In paragraph 6 of the said affidavit, it has been specifically stated that the course undertaken by the petitioner was of 120 hours. That is, i.e., 15 days. Full stop. For ready reference, the said averments are extracted herein below. Page 70, para 6. Full stop. Para. This court has noticed that the affidavit in opposition of the respondents have not been responded to by the petitioner. Full stop. Sri Viswakarma, the learned counsel for the petitioner, however, fairly submits that the brief was subsequently handed over to him, and therefore rejoinder affidavit could not be filed. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Full stop. The contention of the petitioner is that since he was shortlisted initially and his candidature was not summarily rejected, the authorities could not have reopened the issue, that too after completion of a major part of the training.
11th month.
Full stop. Though the petitioner claims to have completed about 11 months,
Yes.
Sri De, the learned counsel for the railways, has submitted that the period of training undergone is of 9 months. Full stop. Para. Though the aforesaid aspect would have some relevance, the length of the period of training undergone would not be a decisive factor for which would preclude the respondents from undertaking a scrutiny so far as the credentials of a candidate is concerned. Full stop. The respondents had granted adequate opportunity to the petitioner to produce the mark sheet to remove any doubts which the petitioner could not produce. Full stop. Though certain reasons have been cited that such mark sheet could not be produced in spite of best efforts by the petitioner, the issue appears to be finally dealt with by the stand taken by the central government in the affidavit dated 17/6/2022. Full stop. In paragraph 6, which has been quoted above, a verification exercise was done on the certificate produced by the petitioner, wherein it was detected that the course undertaken was of 120 hours duration. That is 15 days. Full stop. As indicated above, comma, there is no rebuttal to the aforesaid stand of the central government, which is categorical in nature. Full stop. The requirement of a candidate to have passed out from an ITI with a 1-year course is also specifically stated in the guidelines holding the field. Full stop. This court has also has already noted the submission and the documents relied upon by the respondents, including RBE number 74/95, which specifically lays down the requirement of 1 year training period so far as the post of welder is concerned. Full stop. Para. This court is also of the view that since the eligibility of the petitioner itself is not met, comma, his appearance in the examination as permitted by this court will be of no consequence. Full stop. The writ petition accordingly stands dismissed. Full stop. It is, however, provided that the recovery of the stipend may not be is not to be insisted upon.
My lord, if lordship will kindly peruse page number 10, annexure A on the affidavit filed by the railway.
Yes.
On the last paragraph, my lord, I may be allowed to read. The matter has been considered by the Ministry of Railways, Railway Board, in consultation with Ministry of Labor, Director General of Employment and Training, who have confirmed that certificates issued by ITIs under the aegis of National Council for Vocational Training Scheme towards Craftsman Training Scheme. It is towards Craftsman Training Scheme are equivalent to ITI. Mine is not Craftsman Scheme. I am completely under another scheme, that is National Certificate in Modular Employable Skills.
Now, even that is covered by the central government's affidavit, 15 days.
My lord,
Okay.
since I have already referred to, since the criteria that they are mentioning, my lord, is not applicable to me. The criteria is,
Okay, we're past orders. Yes, next will be someone different. What was the post in the next case? What was the post in the next case?
my lord, actually, I'm not there in this case.
Oh, you're not there.
Next case, the affidavit filed in the present case also covers the next case.
Name is Sanjay Parla.
Parla. Similar.
I was scanning affidavit, my affidavit, paragraph 7. Except 120 days.
Will not say anything on merits in absence of the council. None appears for the petitioner on call, whereas Sri DKD, Learned Council for the Railways, as well as Sri UK Goswami, Learned CGC are present. Full stop. This court has dismissed a writ petition on which was filed on similar grounds, being WPC 5646/2016 within bracket Jayanto Gogoi versus so and so Union of India. Full stop. The Learned Council for the respondent submits that the said order would also cover the present case. Full stop. Para. Be that as it may, comma, in absence of the Learned Council for the petitioner, comma, this court would not like to touch upon the merits of the case. Full stop. Writ petition, however, is dismissed for non-prosecution.
Have a blessed night.
Alhamdulillah. Yes.
Item 5.
এইটো লাগিব দে ৰাতিপুৱা যিহেতু মই তাতে গ'ল নেকি এই যে কিবা মঙলবাৰে যে আহিব কিবা চৰণীয়া নে কি আছিল মোচনটো কি আছিল হেৰি আছিল মানস চৰণীয়া Yes.
Lordship, in this case, Lordship, the last,
Item number?
Lordship,
Yes.
29-2, Lordship, I was directed to obtain some instructions. I have communicated my lord that some of the officers they have been transferred. Now this matter has been my lord looked at by the another my lord additional my lord district commission. My lord, he asked me to my lord that to pray for the some time.
16 matter, Mr.
Lord,
Andy.
this is the approval. So even then, my lord, this matter has been listed only 3 or 4 days.
My lord, initially, my lord, in this case, my lord, I was possessing a plot of land, my lord. I filed a Kapula, my lord. And after Kapula, my lord, the matter was placed before the SDLAC meeting, my lord, Subdivisional Land Advisory Committee, my lord. Thereafter, my lord, the matter was referred to the government, my lord.
Okay, we grant you a last opportunity.
Lord, my lord.
Heard 3A Tiwari, Learned Counsel, for the petitioner, full stop para. 3 J. Hendik, Learned State Council, however, submits that though instructions were directed to be obtained by the last order dated 29/2/2024, he has been informed that the concerned officers are no longer there and therefore he prays for some time, full stop para. Considering that this writ petition is of the year 2016, as an exceptional circumstance, a final opportunity is granted to enable the Learned State Council to obtain instructions, full stop para. List on, yes, tell us a date.
The first week of April, Lord.
1st of April, last date.
Alright, interim order passed earlier, sir, continue.
Para, interim order passed earlier to continue till the next date of listing.
Deeply obliged, Lord.
Already, I have already concluded my submission, Your Lordship. Only I want to reiterate, Your Lordship, that the amount approved in all the LA cases, including LA number 4, was after reassessment, Your Lordship. Your Lordship. But in LA case number 4, after in pursuant to the High Court order, Your Lordship, there was no speaking order and they were granted the amount that was being deducted, Your Lordship. And second point, Your Lordship, in the second round of litigation, this Honorable Court directed to take into consideration our additional affidavit and the plea that was raised by the petitioner, Your Lordship. But the improved speaking order is itself a dicta of the earlier speaking order of 2012. These are the two basically point of my challenge, Your Lord.
নোট কি হলো এটা কাল নোট করেছিল না কিবা নোট করা নাছিল নাকি আর নোট করা নাছিল নোট আছে না কোড পাগল নোট নাছিল নেই Mr. Sharma, what do you say?
Lordship, I am relying on Annexure D of our affidavit.
Just a minute.
That is a
Our sin again, one option. Khalid. No, not in I don't. Khalid মনে ছিল।
আমার এখন কাছে স্ক্র্যাপের করতে আমার
এবার তো আজই লেখা নাই নাকি? এটা তো আর বড় না। এটা ধরো তো বাদে বাদে। তাই শোন, বাদে বাদে। Mr. Malhotra, just brush up the facts. We just, don't find the notes. Yesterday we, I think, made. What, just brush up the facts very briefly.
Your Lordship, I'll summarize it, Your Lordship.
Yes, yes.
In 2000,
There are two writ petitions.
two writ petition for construction of Your Lordship Indo-Bangladesh border road. The land were acquired in the year 2003, Your Lordship, by drawal of land acquisition cases. In the instant case, Your Lordship, initially our LA case was 24 of 2003 and 2004. Subsequently renumbered as LA case number 27 of 2007 and 8, Your Lordship. Accordingly, Your Lordship, an estimate was prepared by the PWD as well as by the revenue officials. And the estimates come to 1,94,38,984. Then, Your Lordship, in all other cases also, estimates were prepared and it was sent to the government for approval, Your Lordship. Now, the government, Your Lordship, in all the LA cases, made a deduction of 15%, 20%, 30%. Not in this case also, in all the cases, Your Lordship. Then we, as well as the affected part of the other land acquisition case, Your Lordship, approached the Honorable Court in the year 2000. First round of litigation is on 2010. Then, Your Lordship, in the instant two cases, Honorable Justice H. Burua was there. He gave a directions, and in LA case number 4, that judgment was delivered by Honorable Justice Amitabh Roy, Your Lordship. In that case, after passing of the order, there was no speaking order, nothing, Your Lordship. Directly the respondent authorities have paid the.
Where is the order passed in your case?
In my case is annexure, Your Lordship, 8, page 50, Your Lordship.
50.
50. 50.
Yes.
Relevant from page 51. Page 51. Second paragraph, the petitioner therefore being deprived of the balance compensation committed by the district collector has approached this court by filing this instant writ petition, seeking a direction to the respondent authorities to release the balance amount in favor of the district collector to facilitate him to disburse the same among the landowners, including the petitioner. I have heard so and so, so and so. State respondent in the counter affidavit has admitted the grant of compensation to the tune of rupees 1 crore 94 lakhs odd, and also of release of amount of rupees 1 crore 68,000 odd for disbursement of the same among the landowners, including the petitioner. There is no averment in the counter affidavit in regard to non-release of the balance amount of rupees 26 lakhs odd. Mr. Vishal Learned Counsel, in view of the computation of the compensation to the tune of so and so and release of so and so submit, there can be no reason on the part of the state respondent for not releasing the balance amount as indicated above. Mr. Vishal therefore urge this honorable court to issue a direction to the respondent authority to release the aforesaid amount in favor of the landowner, including the petitioner. Counter affidavit so filed by the respondent is also silent in respect of the causes for not releasing the balance amount. Mr. S. Saikia, Learned Standing Counsel, PWD, while submitting before the court, states that the Revenue Department has only given approval for release of 1 crore 68,000 despite computation of compensation to the tune of 1 crore 94 lakhs odd. Therefore, in view of the above, there can be no balance so to be paid to the landowners, including the petitioner.
That we have read. Last 52, as the counter.
Yes, 52, your lordship. As the counter affidavit filed by the state government is silent about the causes for not releasing the balance amount as indicated above, this court find no impediment to issue a direction to the respondent authority to release the balance amount in favor of the landowner.
That we have seen.
Yes,
This is with regard to your case,
my case,
Tajuddin.
Tajuddin.
What was the LA case here?
My LA case renumbered as 27 of 2007,
Where do you get in this order?
your lordship.
In this order, is there any reference to the LA case? No, I don't think so.
No, in the order, there is no reference.
Okay, doesn't matter.
Yes. So the direction was, your lordship, to the respondent authority.
Okay, that we have seen. That-
Yes.
And then,
Okay, there was a write-up before releasing the amount, the landowner, including the petitioner's claim, will
okay.
be verified and if found.
And at 54 is another, so for
Yes, similar,
similarly placed.
yes, that is by Honorable Justice Amitabh Roy, your lordship.
1111.
That was in respect of land acquisition case number 4, your lordship. I am reading the relevant to paragraph, your lord, page 55. Upon hearing the learned counsel for the parties and on a consideration of the written instruction as referred to herein above, reflecting the stand of the respondent, it is considered expedient to close the instant proceeding.
See, but you are claiming that you are similarly placed.
Yes,
But the LA case, obviously these are, the numbers are different, but even the year is different. This is of LA case 67.
no, it is, yeah, my original LA case number is 24 of 2003 and 4.
Yes,
Then it has been renumbered.
renumbered as 27 of 78.
Yes,
But the LA case, which was the subject matter of 1538 of 2010,
yes, your
is
lordship.
of 67.
No, yes, 67.
67. It is not contemporaneous.
No, that has also been renumbered, your lordship.
Huh?
All lands were acquired in 2003. And for the same purpose, these are all adjoining villages, your lordship. Adjoining villages.
Hmm.
Now, pursuant to the order passed in LA cases, your lordship,
Hmm.
your lordship may kindly see Annex 13 and 14, page 60.
Now here what happened in the WPC of Maulana?
1538.
1538.
Then pursuant to this judgment, your lordship,
What was the judgment? Pay.
Pay 55 relevant portion,
No, judgment was to pay.
pay. Would notify the petitioner and release them their due on proper identification. As the petitioner waits for expectation for nearly a decade after acquisition of the land, the process has
Then this was paid, you said.
yes,
The balance in the Maulana was paid.
paid Annexure 13 and 14. I have enclosed to
Page
60.
60.
60. 60. I have annexed the payment voucher of 2 of the pattadas only, Your Lordship, which I could collect. May I read, Your Lordship? On the left-hand side column, Your Lordship, 1, 2, 3, certified that this is 100% of Jirat compensation at village so-and-so in LA case number 4 of 2006-7, and the pay is entitled to get the compensation in DAG number so-and-so for an amount of rupees 1,18,982. And
Yes, we have seen that.
and next, another voucher at page 61, Your Lordship, in LA case number 4.
Okay.
So basically, my contention is this disparity between the two LA cases.
And what is this page 56?
Page 56, Your Lordship.
Order dated 2/7/2012.
Yes. This is the speaking order pursuant to the first round of litigation. Both the two cases.
21/7.
Yes.
12.
Yes. They contended that reassessment has been done, Your Lordship, page 56.
Yes,
Their contention is that, may I read, Your Lordship?
please.
I read from the third paragraph. From the report of the land acquisition officer Silchar, it is found that he heard the writ petition of Tajuddin so-and-so and Adijul Haq at length on 19/7/2012. They submitted that their agreement prepared writ petition before the Honorable Court because 30% of their Jirat compensation assessed by the executive engineer Silchar has been deducted by government, and they are poor from and it is not possible to construct a dwelling house with the compensation amount received by them. They should be given the deducted amount. The executive engineer PWD Silchar, Sri P.K. Dev, stated that it is a fact that his office has assessed the Jirat value and has submitted the assessment list to the deputy commissioner. Later, this office received a communication from the chief engineer in which he has intimated his intention to visit Silchar on 19/8/2005 to 21/8/2005 for physical verification of Jirat. That is after 2 years, Your Lordship, at village so-and-so, and visited this site as per schedule and has reassessed the value of Jirat. Jirat doesn't only means the building and pond, Your Lordship. Jirat also includes the trees, valuable trees. Next page, Your Lordship. From the communication of the chief engineer dated so-and-so, referring government letter dated so-and-so, saying that the revenue department raised objection for valuation of Jirat, it appears that the objection has been raised by the revenue department on the assessment of Jirat value. Sri P.K. Dev further stated that he has nothing to comment on the reassessment of Jirat value by superior authority. Obviously, he will not raise. The executive engineer, PWD Border Roads Construction Division, Badarpur, stated that his department has deposited fund for payment of compensation to collector as per approved estimate received from government in revenue department and has completed, and at this stage, he has nothing to comment on the issue. On perusal of the office record, it is seen that while letter dated so-and-so forwarded that statement of Jirat which was checked and verified by the chief engineer in LA case number so-and-so, and the deputy commissioner was requested to resubmit land acquisition estimate. These two cases are not relevant to me, LA case number 15 and 25, Your Lordship. And the deputy commissioner was requested to resubmit land acquisition estimate on the basis of above verified valuation of civil engineer construction structure for the LA cases. From the LA case record, it is seen that the government in Revenue and Disaster Management Department by letter dated so and so has approved has forwarded the approved LA estimate for LA case number 27 of 2003 and 4. There is a typographical mistake. It should be 27 of 2007 and 8. Second case is mine, your lordship. 27 of 2007 and 8. Second one. LA case number so and so. Thus, it is clear that the derived value was reassessed by the chief engineer, who is a technical head of assessing department, and it was accepted by government in revenue and disaster management, and accordingly has approved the LA estimate.
Yeah, we have read this.
So my submission is that, your lordship, derived doesn't only means building and ponds, your lordship.
But yesterday we have seen that
Building and pond.
it is not because of non-taking into consideration certain trees which may not be existing after 2 years, as the road have already been constructed.
Yes.
But the deduction is only because of a proper assessment of the pond and the building
Yes.
as per PWD norms.
But this
If
speaking
your,
order,
if your contention was that there were trees
yes,
and after 2 years trees were not there, so DJAT has been,
all
the
along my
value of the
contention is
DJAT has
Jirat.
been reduced.
All along my contention was Jirat. Jirat includes trees, your
No, no,
lordship.
but that the reduction is not on account of trees.
And the speaking order doesn't say so. It say about the Jirat.
No, no, no. Yesterday I've got,
Yes, there is a communication, subsequent communication.
yes.
Yes. They have shown it from the communication. Now, your lordship,
Hmm.
then again challenging this order.
Page
For
30.
me, let me.
Please.
No, I'm just pointing out that ponds and
30.
only that much.
30.
30.
3.2, annexure 1 of the writ petition. I'm just only pointing.
Yes,
out.
yes, yes.
I'm not.
No, 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 no.
disrupting.
Yes,
Last paragraph.
Yes.
last paragraph. Value of houses and pond are corrected as per reassessment.
This of which
2005.
2005.
2005.
Okay.
So even assuming, not admitting your lordship,
Hmm.
that upon reassessment, they have come down, that the houses and pond has been valued higher, your lordship.
Hmm.
That has also happened in other LA cases also. And they have not given a clear finding what has been on higher end, which
Okay.
Hmm.
Then you had
Then-
come again. You had come again thereafter.
again, your lordship,
Yes.
yes. Then I came again, your lordship,
At page
page
63.
63, your lordship.
63.
page 63. Relevant, I will just give your lordship. Start from page 69, para 14, your lordship. My one issue is disparity. Number 14 is having regard to the above controversy raised in the writ petition and also considering the matter in its entirety, both the writ petition are disposed of, directing the LA collector to take into account the aforesaid plea of the petitioner and decide whether any review of the order impugned in this proceeding is called for. In any case, the state authority shall pass a speaking order taking note of the aforesaid plea raised by the petitioner in the writ petition as well as in the additional affidavit filed on 22/03/2013. In this additional affidavit, we have shown how we have been discriminated, your lordship. Now, if your lordship kindly see the impugned order, impugned speaking order 17. It is a dicto order of 2012, your lordship.
Page
It start from page 17, your lordship.
71.
71, annexure 17.
Date?
Date is 23/6/2014. The contention of the speaking order is what has been in challenge in the earlier speaking order, dated of 2012. To my additional affidavit, my plea was not taken into consideration. So specifically, what has been directed to take into consideration in the second round of litigation, if the authority take into these two plea, I think the matter, it will suffice, Your Lord. I am not claiming that I should be given, let them take into consideration all these facts.
What are the other cases where money has been paid as per the original estimate?
In second case, Your Lordship,
No, not this, not Azizul case. What are the other cases where the entire money as per estimate?
Your Lordship will get it from
That Maulana's case, Lord.
Your Lordship, page 41, your Lordship may see, page 41. There is a chart of the four of the LA case, including our cases. One is LA case number 4. The initial estimate amount was 1,35,000. Government approved and initially paid 1,18,000, 18 lakhs. And after the High Court order, the balance of 17 lakhs has been paid. So also though I am not having any record of LA case number 29, it is learned that herein also the balance amount has been paid. And 3 and 4 is our present case, Your Lordship.
Have you stated in your pleadings that so far as 1 and 2 are concerned,
Yes.
those are in the similar footing?
Yes, yes.
Which paragraph? Okay,
Para 18, page 17, then
17, 18.
Para 19, stated that the respondent have also made payment of direct compensation to six affected.
Para
18, 19. Then so in my submission part, Your Lordship.
Okay. Okay, Mr. Sharma.
Lord. Page 32, Lord, connector 1. Just now I have placed before your Lordship regarding that. Page 32, last paragraph. This is dated 10th of November 2005. The value of the houses and ponds are corrected as per reassessment. This word is important for reassessment. Means it was reassessed. My learned friend is relying on the judgment of Honorable Justice Amitav Roy, Lordship. In that case, the Jirat, the balance amount has been paid. But there is a slight difference between the case of the petitioner and this Maulana Arun Rashid's case, 1538. In this order itself, there is no any whisper regarding any objection raised. But in the present case, if your lordship comes to page 56, that order,
Yes.
last part, page 56, last paragraph. The executive engineer, PWD Building Division, Silchar, so-and-so stated that it is the fact that his office has assessed the Jirat value and has submitted the assessment list to the Deputy Commissioner Kasar. Later, his office received a communication letter dated so-and-so from the chief engineer PWD Assam, in which he has intimated the intention to visit Silchar on so-and-so date for physical verification of Jirat in so-and-so. The chief engineer PWD Assam visited the site as per schedule and he reassessed the value of Jirat. Next paragraph is important. From the communications of the chief engineer so-and-so, referring to the saying that revenue department raised objections for valuation of Jirat, it appears that objection has been raised by the revenue department on the assessment of Jirat value. So in this particular plot of land under the LF 27 lordship, in this case, it is apparent from the record that there is an objection. Because of this objection, the reassessment was made. And because of that reassessment, the new valuation has come up. But in other cases, lordship, I have not seen any such objection. Accordingly, lordship, my learned friend has relied upon that the vouchers payment, those were paid. That amount were paid. But in this case, objections was raised by the revenue department. Accordingly, reassessment was made, and accordingly, the valuation was fixed, and that amount has been paid. That is my whole contention, Lord. So they cannot say that they are similarly situated. Had there been no objection, Lordship, I would not have, yes, they have a case. But as because there was an objection, accordingly reassessment was made. Amount was refixed. That amount was paid to them. They have accepted it without any objection at that time. Whether now their claims is acceptable. That much, Lordship, as because my learned friend has already stated. But regarding that Maulana's case, Lordship, I don't think that their case and Maulana's case on the same footing. As because in that case, there was no such objection. From the order itself, no such reflection is there.
May I please, your lordship, if your lordship permit me? Annexure 6, Annexure 6, page 43. Your lordship, reassessment was done in every case. Your lordship may kindly see Annexure 6, page 43. May I read, your lordship? Subject, acquisition of land for construction of IBB road and fence in respect of LA case number 1, 4. That means the similar case, 2006-7. Number 2, 29 of 2007-8. Number 3, my case, 27 of 2007-8. Number 4, 16 of 2007 and 08, my second case. Government letter dated so and so. Sir, with reference to the above, I have the honor to inform you that initially the land acquisition estimate of all LA cases were submitted, including Jirat value, as assessed by the executive engineer PWD Building Division Silchar. But when the land acquisition estimate was sent to the government and the same was approved after deducting Jirat value of 15, 20%, 30%, etc., and instruction for furnishing the award as per the approved estimate. Accordingly, the award was sent and the same was approved by the government. Further, the point was reply is furnished below. And then also I am to say, concluding, also I am to say that total deducted amount of Jirat in all cases, your lordship, not in my case, comes to 1 crore 40 lakh, so and so, only as claimed by the land loser. So there was also objection. We are claiming for the remain. A detailed statement in Annexure 1 for the same is enclosed. Then enclosed 6A, Your Lordship. So reassessment was done in all cases, not in my
Nowhere it is
case.
mentioned that reassessment was done,
From
but in that
this-
particular order, Lordship, I
From
have
this,
seen.
if
Yes,
that is to be-
deduction was made.
If that is
Deduction
to
was made.
so, then I have to call the record of the LA case number 4, Your Lordship. In that petition, it is available, because in that case also I was a petitioner. I was the one of the counsel, Your Lordship. I know there was also reassessment. And it reflects from the annexus 6, Your Lordship. In all cases, there was initial deduction of 15%, 20%, 30%.
I am not denying against the deduction. Yes, deduction was made. But in this particular case, there was an objection because of the reassessment.
No, the communication which Mr. Mazumdar is trying to rely upon and have placed before this court, 15th of December 2009.
Yes,
This pertains to not only the case of the petitioner.
yes, all the cases.
All the cases.
But but nowhere it is stated that these lands are to be reassessed. These lands were, yeah, deductions were made. As because in some cases, without there being a reassessment or without there being an objection, that balance amount was.
But Mr. Sharma, you have seen both the speaking orders. The first one,
Yes,
after the order passed on 7/4/2011 by this court.
yes, Lordship.
Okay.
They are
And thereafter the second one, after the second order was passed by this court
yes,
on 3/4/2014.
23.
yes.
No, the order of the court is 3/4/2014.
Yes.
And
Now the
speaking
final order, which is passed on 23/6/14,
Yes,
appears to be a replica of the earlier
Yes.
order.
As because facts is same, we have nothing more to add or in.
No,
Thereafter,
There are.
thereafter,
Because Honorable Justice Sharma's order of 3/4/2014 had directed you to take into consideration the points taken in the additional affidavit also.
Lord.
Back, but go to the affidavit filed by the revenue department.
In Tajuddin case.
Sir.
By Asim Kumar Bhattacharya.
No, it is by Dilip Kumar Das.
Dilip Kumar Das,
And there is also a reply to our reply also.
they have been filed a reply. Lordship, may kindly the internal page 29 of the affidavit,
Yes. 29.
29.
Yes,
This is
please.
these are the, my lord, that reassessment of the missing Virat. These are the this which LA case, my lord, they have been mentioned. This has been done. There are what was it, 5, 6, my lord. the LA
Page
case.
29.
Page 29 of my affidavit.
Yes. Yes, please.
So in the letter, lordship, there is no mention about our regarding, my lord, LA case number 27, lord. 29, 2007, 2008, 4, 2006, 2007, 17, 2003, 2004, 28, 2003, 2004, 26, 2007, 2008, and 25, 2007, 2008, lord. According to this, my lord, there is a missing Virat has been, my lord, reassessed again, my lord, that this are, my lord, this amount has been, my lord, calculated and estimated. It was sent by the, my lord, that PWD to the, my lord, the revenue department.
Let us do one thing. We have already given sufficient time in these matters. Matters are of long pending matters. Let us have the record of the other case. It's in the court itself.
Look.
We'll just have the record of the disposal of matters. Have a look what was the consideration. And if we find that everything is identical, then otherwise injustice will be done.
That can be done.
In our affidavit, we have already been, my lord, stated that, my lord, that Dirath had been paid.
Heard the learned counsel for the parties. Full stop. The principal thrust made on behalf of the petitioner is of disparity. Full stop. Whereas in a similar LA case 4 of 2006, 2007, pursuant to an order dated 11/11/2010 passed by this court in WPC 1538 of 2010. But 2010 record, will it be there?
Your lordship may kindly take in consideration my that part, lordship, that in this particular case, that objection part. that is
No
the-
objection, Mr. Mazumdar has said objections were in respect of other cases also. Same
Yeah.
objection,
that-
same objection.
But in the orders, lordship, there is no such objection. That is why, because I have also no record.
But 2010 records, will it be there after 14 years? No, I don't think so. Second file is here.
Can it be
And
met?
in addition to that, my
এটা ফাইল তো সদায় মানে eternal থাকে না?
Your lordship, may I interrupt you?
Yes, no, we'll call for the record. Yes.
Correct.
Pastor, okay? 1538/2010, comma, the balance of the estimated amount has been paid to the concerned party, full stop para. In the interest of justice, comma, let the records of WPC 1538/2010 disposed of on 11/10/2010 be tagged with the records of this case for consideration, full stop para. List on next Thursday. Next Thursday. Tuesday we have fixed matters.
20 and 21, lordship, there is some ceremonies there, lordship. So may I pray?
Then 22.
22 or 27, any date? 22, I am available.
22. Friday.
Lordship, kindly allow the direct our name reflected in the.
Okay.
We are making the.
Okay.
Revenue
Cause
estimate.
list to reflect the names of Sri H. Sharma, learned additional senior law advocate, and Sri J. Hendik, as you are for revenue,
Revenue.
as standing counsel revenue department.
Obliged.
May it be so. Allowed us. As because item number 9 and 17, can it be taken up next Thursday, man?
Why not today?
Other matters that they have.
9 will come right now. We have one matter of Mr. K. Agarwal. He had mentioned it. It will not take much
And
time.
my item, it will take some time, my lord.
What are these matters, your matters?
My lord, 9 is property societies matter.
9 will not take time. 9 is a short matter.
9. Or it can be taken up on 21st. sir.
9 and how is 10 connected?
Not 10, my lord. 9 and I am, another matter is there.
9 is
Seven-
the Bedarpur milk production.
Mm,
It's short matter.
my lord, it is against in the appeal and review. All
That will not take time. Wait for a while, Mr. Agarwal matter will be over very soon.
Yeah.
Yes, other side, somebody was there yesterday. Somebody was here yesterday, you said.
Sharma. That would take.
Yes.
Right.
Huh?
Huh?
My question আছে।
It is a great. It will hear matter.
বিচাৰি আছো নাই পোৱা। নাথাকি কথা। Yes.
Captain of reporting. Not the in this case, Future Retails Limited having a large departmental store at Jorhat Big Bazaar.
Future Retail Limited.
हाँ.
Six, eight, 3 of 16, yes. You had a store at Jorhat.
Jorhat. And the matter pertains to the Jorhat store.
Okay.
What happened on 24/9/2016?
Yes.
But the date is relevant. On 24/9/2016, the officers of Food and Civil Supplies came. And your lordship can kindly come to page 43. They give us a notice that relevant records, documents, license relating to your business establishment for court inquiry and conduct. Your lordship will kindly see page 43.
Yes.
This Chan Bose, he was store in charge. So all purchase memo of pulse, sale case memos, vouchers of pulses and arrival was relevant license related to business like trade license, legal methodology license, etc. State stock position of the date of sale, categories of pulse, arrival oil, go down capacity, rent agreement of the business permit, any other document relevant to the business. Now, pursuant to the notice, we submitted certain documents, my lord, at page 45.
45.
45. Annexure 8.
You submitted your reply.
Not reply, my lord. They on the spot, my lord, they asked, my lord. Then in writing, we have given this. That this is reference to so and so, copy of trade license, legal material license, authorized signatory letter, stock position on the date of sale. We need extra time of 7 days to provide rest of the documents as we need to collect the same from our concerned department.
Yes.
Now, my lord, the issue is not that basically. Now the documents are given. They made this search, my lord, in the premise.
Yes.
Page 46. Annexure 9.
46.
46.
Yes.
During the period of inspection and search in premises of Big Bazaar, so and so, by the district administration team on 24, the following tally sheets of pulse is prepared and displayed below. Now, pulses in plastic bag, the lordship will find total 11.70 quintals. Pulses loose containing in categories 5.34 quintals. Then pulses all loose of 1 kg 500 gram, total 18.
Okay.
Okay. One of those ultimately 35.54 quintals of pulses were found in the premise.
They have prepared this what? Inventory or what?
Inventory. Thereafter, the seizure was there. I'll place
Seizure was also there.
Seizure is also there at page 48. Now, my lord, they say that 10 kilo pulses is permissible to be kept in premises. So, besides 10 kilo, around 25.2 kg, this is the indirect. At page 48. Seizure list, my lord will find at page 51.
40, what is 48?
48 is not only, they say that the static statement, what they found.
Okay, 51 is?
51 is the seizure list of total seized pulses 25.2 kg. I'm sorry, quintals, my lord. 25.2 quintals.
Where do you get?
My lord, your lordship, last part of page 51.
Okay.
Earlier, my lord, 39 packets of so-and-so pulses, 11.7 quintals, 70 quintals.
No, you prior to that 39 packets of pulses, that is also there. 11.70.
Then the next is, my lord, 13.5.
Okay, total is 25.2 quintals.
Yes.
Seized, okay.
Then page 53, that those items were given in my Jima, in the Jima of the store in charge, page 53.
Which items? This
Those
is,
25.2 kg,
okay,
these articles.
okay. Yes,
Then, my lord, on 24/9, this has happened. Then on 15th of October 2016, my lord, page 55,
Hmm.
we have written to the Deputy Commissioner
yes,
that, my lord, these are the goods which may be damaged or destroyed
for releasing.
for releasing them.
Hmm. Yes,
Now, my lord, instead of releasing them by page 56, order dated 21st of October 2016,
Hmm.
my lord, the direction was there that you sell this, distribute this item of 25.2 kgs amongst the, my lord, 19 numbers of Amar Dukan of Jorhat town at prevailing market price, and sale proceeds of the same is ordered to be deposited to the government treasury under proper head of account for treasury challan as per norms till disposal of the case. কিমান পইচা পালে সেইটো লেখা নাই। এইটো আহিব। Now, my lord, this is the position so far 24/9/2016 is concerned. Their
Yes.
allegation, if your lordship kindly come to page 48,
48,
that has reflect that what violation we have done.
okay. Yes,
Now, my lord, your lordship will kindly see the last column, discrepancies detected remark.
Hmm.
The retail store is found in position of pulses, all categories above the quantum prescribed in Schedule 3 of 88 to Order 1982. Actually, Assam Trade Articles Licensing and Control Order 1982 without position of varied license. Also contravene clause 2U. It should have been, my lord, 2U. I have found later on it is 2U, not 22. 3 and 18 of the control order regarding so and so dated 18th October 2015. My lord,
yes,
to just apprise my lord, may I take my lord to the trade article, Assam Trade Articles Licensing, etc. Order 1982, my lord, we have annexed at page 24.
24,
Page 24, we have annexed that entire.
yes,
So lordship kindly stand to page 26. Page 26. Retailer means a dealer dealing in any of the trade articles mentioned in Schedule 1 and who is not a wholesaler. Then
page
clause 3,
26, page 26,
page 26, my lord, 2U, 2 small u, my lord, in bracket.
yes,
Retailer means a dealer dealing in any of the trade articles mentioned in Schedule 1 and who is not a wholesaler.
Hmm.
Now, next, this is a violation of section 3, clause 3. Clause 3 is licensing of dealers. No dealer shall, after the commencement of this order,
yes,
carry on the business of purchase, sale, or storage of sale of any of the trade articles mentioned in Schedule 1, except under in accordance with the terms and conditions of a license issued in this behalf by the licensing authority under the provision of this order. So this requirement is that you should have the license.
Hmm.
Now, in Schedule 1, if your lordship kindly turn to page 33.
Hmm.
Pulses comes within schedule 1. Count it.
Yes.
Now, provided that provision is important, provided that no license shall be required for a dealer who stores for sale at any one time the trade articles in quantities not exceeding the limit as indicated in Schedule 3 of this order, or as may be prescribed by the state government with prior concurrence of the central government for any trade article from time to time. Now, Schedule 3, your lordship will find at page 34.
Yes.
Pulses, serial number 4, 10 quintals.
Hmm.
Now, my lord, may I just come again to clause 3? My lord, exceeding the limits as indicated in Schedule 3, proviso, my lord, I am reading, to this order, or as the case may be prescribed by the state government with prior concurrence of the central government. This is very important. This is 1982 order, my lord. I'll come. That will not the licensing and other things will not removed by an order of 2002 of the central government. I'll come to that. I just been pointing to my lord. Now this is 18 now. My lord may come to 18. Clause 18 at page 30.
Yesterday, I had,
My lord,
applied that.
short question is, my lord,
Yes.
that my lord, they have told it out. 1,56,000 and odd was, my lord, they deposited in treasury. Now, my lord, this honorable court, by order dated 16/11/2016,
Yes.
equal. I'm just showing. The order I'll just put. First order dated 16/11/2016 of this honorable court, my lord.
Yes.
Second pair I am reading. It is submitted by Mr. Hajarika that the goods, namely 25.2 quintals of first seized on 24/9/2020 were sold out and so various outlets of Amar Dukan of Johar Town in terms of so and so, and an amount of which 1,53,000 has been deposited in the treasury on 10/11/2016. Then issue notice and all that.
Yes.
Last pair of that. Needless to say that amount deposited in the treasury shall be subject to the final decision taken by
Yes,
this
yes.
court in this. Now, look, our one contention was that
Yes.
my lord, we have challenged the order of my lord disposal of the my lord pulses by the deputy commissioner. But since it was already no stay was granted, it was disposed of, the court says it will be final decision. So this is the position so far is concerned.
Okay.
So far the my lord
The amount is still lying in the treasury.
treasury. Now, my lord, second issue was that we prayed in this court before this honorable court that since they said that you are required to have a license, then immediately we applied for a license. They were not giving the license. So in this writ petition, we prayed that kindly give a mandamus to them to grant the license. Now, in the meantime, my lord, in my affidavit in reply, filed on date to the file. But I don't find the date. Huh? July,
Your
18th of July 2017.
Your Cyan Bose.
But Cyan Bose. But I'm not taking the entire 2 million, my lord. I'm just pinpointing one aspect of the matter.
4th of August 2017.
Yes, my lord. Page 2,
The running page is 75, madam.
page 1. Page 8. Regarding issue of retail license under trade article licensing 1982, your department outlet. Honorable High Court order in WPC. Inviting reference to the subject above, I would like to inform you that as per Government of India notification number so and so, dated 29/9/2016, issued by Ministry of Consumer Affairs, Food and Civil Supplies, And also concerns with the government notification dated 19 December 2020, the Governor Assam is pleased to remove the licensing requirement on certain food reserves for a period, and your departmental outlets falls under the exempted category. So they say that there is no requirement. So in this regard, as per the provisions contained in the GSR as specified in clause 2(3), you are required to declare your stock, pulses, edible oils, edible oilseeds and sugar for the purpose of calculation of stock limits on soil.
Yes.
So these are the two issues basically are in this writ petition. So the second issue, my lord, with regard to issuing of the license, that does not survive because of this say that no, you are not required. But still then.
Now, what is the existing grievance?
Grievance is just 1,53,000, my lord, that is lying.
Okay.
And my lord, consequent to this seizure, my lord, they ultimately, my lord, gave the sanction for prosecution and an FIR was lodged. And my lord, we challenged the entire proceeding, my lord, in a my lord, petition under section 482 of the CRPC. And that is pending, and my lord, that I have indicated in paragraph 14 of my affidavit in reply, which my lord has just now taken.
Yes.
Paragraph 14.
1-4.
Page 5.
Okay. That's
An
what-
extra copy. My lord, this is basically, my lord, what I am trying to say. My lord, at this stage, the other issues does not survive. My lord, entire other matters are, my lord, being challenged there. And in fact, what happened, my lord, I'll just take 2 minutes of my lord, my lord. But my lord, actually, when the 2002 order was, my lord, issued, my lord, first was included in 2003. And my lord, the clause 4 and 5 of that order says that once an order is issued and a material is already, article is already included in this, if the state government has to make any regulation in this regard, then they have to take the prior approval of the central
No,
government.
that expression is or.
You know?
Expression
Not
is-
here, my lord. In that order, my lord. That's what I am saying. That order, if your lordship kindly,
Which order?
that 2002 order.
One you have next year.
No, that is not annexed here. That order is not annexed. Well, that is an 1982, my lord, order.
Okay. Yes, 82 have annexed.
Annexed 82, I have annexed.
And this one?
This is, my lord, all the notifications issued under section 3 with regard to, my lord, may I take to page 2, my lord.
Phase 2.
Whereas the central government is opinion the necessary and expedient to do securing of the availability of committees specified in the order as fair prices throughout the country.
Yes, which provision, which part?
My lord, I am reading, my lord, the short title and extent and commencement. Case 2, last part, my lord. The central government has made this order under
Yes.
section 3. This order may be called removal of licensing and requirement, stock limits and movement restriction on state food stuff, order 2002. Then, my lord, your lordship will kindly see dealer has been defined. My lord, I'm leaving all this, my lord. Your lordship will kindly come to clause 3. With the coming into effect of this order, any dealer may freely buy, stock, sell, transport, distribute, dispose, acquire, use, or consume any quantity of wheat, paddy, rice, coarse grain, sugar, edible oil, seeds, and edible oils, and shall not require a permit or license, therefore, under any order issued under the essential commodity.
Okay.
Here, my lord, pulse was not there. Pulse was included in 2003. I'll come to that. My lord, your lordship will kindly see, issue of any order, 4 is important. The provisions of this order shall take effect notwithstanding anything to the contrary in any order made by state government before the commencement of this order, except as respect anything done or omitted to be done thereunder before such commencement. A 2002 order was, my lord, issued in February 2002.
Hmm.
Now, my lord, number 5 is very important. Issue of any order by the state government under powers delegated in GSR 452E dated 25th of October 1972, issued by the Government of India in the then Ministry of Agriculture, and GSR 800 dated 9th of June 78. My lord, this 1982 order was issued in view of the delegation made by the notification GSR 800 dated 9th of June 1978, issued by the Government of India in the Ministry of Agriculture and Irrigation for regulating of license, permit or otherwise the storage, transport, use or consumption of committees shall require the prior conclusion of the central. Clause 6 is not relevant because that relates to it says that after coming into force of the 2002 order, if the state government has to deal anything which is included in the order, then prior concurrence has to be taken.
Any of the commodities referred in clause 3. You have said that in 2003 pulse has been.
2003 pulse, yes. 2003 at page 7, my lord. My lord, in page 7, clause 3, in clause 3 of the order for worst and edible oils, the following shall be substituted. Pulse was included. And thereafter, my lord, thereafter, various orders were passed. Sometime, my lord, it were exempted from the operation of the 2002 order. Sometime again, it was included, my lord. In 2007 order,
But one thing may still arise. This at page 2 is an order of 2002.
Yes, sir. 2000.
When in 1982 the state order was already in operation.
In operation.
Now the explanation we have to fall back on clause 4.
Clause 4 and clause 5.
Clause 4. No, the 5 will come, but before that 4. Provisions of this order means 2002 order.
My lord.
Can you come to clause 4?
Yes, my lord.
Please read. The provisions of this order means 2002 order, shall take effect notwithstanding anything to contrary in any order made by a state government before the commencement of this order, except as respect anything done or omitted to be done thereunder, before such commencement.
Well, if something has already been done, or something has already been omitted to be done.
Notwithstanding anything contrary.
Well, a person has been, my lord, fine was imposed on him on the basis of 1982.
That is saved.
That will not.
That is saved. That is okay. But will it alter the position of the 1982 Act?
My lord, order and my lord, in fact, in some of the decisions of our High Court, 2 decisions I have found, my lord, they say that, my lord, concurrence of the central government was not taken while the enacting 1982 order. 2 decisions are there. Because, my lord, 1982 order, if your lordship kindly, for timing, my lord, I'll just go. My lord, the delegation was made by notification dated 1978. the Lordship will find reference of this notification in my lord, clause 5.
Yes.
My lord, Delhi so and so, order of Government of India, Great Ministry of so and so, the central government hereby directs that the power conferred on it by subsection 1 of section 3 of the State Act to make orders to provide for the matters specified in clause A, B, C, D, E, F, H, I, Roman 2, J of subclause 2 thereof shall in relation to.
But we may not even go to that aspect. After 2002, the requirement of license has been done away with.
Done away, but my lord, in certain notifications I will show, my lord, they state it will be exempted from this order. Like pulse for 6 months, sometime for 1 year, my lord. This factual position, my lord, I cannot deny. But my submission before my lord will be that even that particular point of time,
Yes.
that the 2002 order was not made applicable so far pulse is concerned. Even then, my lord, if there has to be any order has to be made in respect of pulse regulating their control by the state government.
No, you have said that in 2003.
2003 it has been included, my lord.
Yes.
But my lord, later on your lordship will find in some of the year, if your lordship kindly take page 10, my lord.
Of the compilation.
Compilation.
Yes.
My lord, clause 2. In the words and expression made in respect of purchase, movement, sale, supply, distribution of stores for sale of so and so, shall be kept in abeyance for commodities, namely wheat and pulse, for a period of 6 months.
Okay. Thereafter?
Thereafter it will again apply.
No,
So, my lord,
after 6 months, what happened?
well, 6 months there, either they will, my lord, extend it.
No, what has happened thereafter?
Thereafter, my lord, February 2008.
Yes.
Page 12.
For a period of 6 months, another 6 months.
6 months. Then, my lord, August 2008. Page 14.
When is the last extension?
Last 15 months. 2015, my lord. If your lordship kindly come to
25.
in removal licensing stroke limits on so and so. My lord, clause 7 was, my lord, introduced later on, my lord. That, my lord, the lordship has to take it from the other notifications. The following shall be substituted, namely pulse, edible oils, and edible oilseed for a period of 30th September 2016. Provided that nothing contained in this item shall apply to, my lord, this is important. Retailers, clause C, retailers, multiple outlets, and large departmental retailers from stock holding limits under the Essential Commodities Act 1955. But they were, my lord, exemptions were given in respect of these 4 categories of her.
First day of October.
Now, on 28th of September 2015, thereafter another order was issued in October 2015. Page 28.
Yes.
Now, in clause 7, they say that the worst pulse, wherever it occurs, shall be omitted.
That means pulse will still remain as a restricted good.
Then,
But the last one, which you have annexed at 29th of September.
Yes, my lord. 28th of September.
28th of September.
We were given the exemption.
But this exemption is also for pulse, but this came into effect from 1st of October 2016. And your cause of action took place in September 16.
24/9.
No,
24/9/16.
my lord is saying.
You are at page 30. This order is of 2016, 29 September.
Oh, that is a different, my lord. My lord, I am not harping on that. That will not cover my period, man.
Yes.
That will not cover my. I have given because, my lord, in that time, the 2002 order was, my lord, wiped away and new order of 2016 came into.
Yes.
But my case is of 24/9/2016, so it will not cover. But my lord will kindly see page 25.
25, yes.
my lord, the last part of it,
Yes.
provided that nothing contained in this item shall apply to retailers, multiple outlets and large department details from stock holding limits under the essential committee. But thereafter, another notification is there of October.
Now, at the time of the occurrence,
Yes, my lord.
namely 24/9/2016, what was the law prevailing?
The pulse was exempted from the two order. Pulse was not an item, part of the item in 2000.
2002,
No,
Pulse was not there.
no, the 2000
2003, Pulse included.
Included.
But it was extended
Time
from,
to time, they say
the
that
operation was restricted from 6
restricted to
months,
them.
6 months.
In this case also, they have restricted till 30th of September 2016. In the notification dated,
That means it was a period where the restrictions were still there.
still there. But in September 2015, it specifically says that it will not applicable so far the large departmental store, then exporters, stock essential commodities meant used for raw materials and licensed food processing industries. ASTC, page 25.
Yes, 25 verses.
So I come within the purview of Lord C.
Retailers.
Yes. You're right. But there is another notification of 15th of October, 18th of October 2015.
Hmm.
There when they say that the pulse will be omitted from clause 7.
Hmm.
And they say that the restriction will continue up to 30th September 2000. Page 28.
Now this page 25,
Yes.
where a reference has been made to the removal order of 2002.
Yes, my lord.
Where is clause 7 in 2002?
Well, it was later on introduced, my lord. I'll just place before, my lord, that order is also here.
Because neither in
My lord, your
2000
lordship, page 21, your lordship will come.
21.
Then at that point of time, it was introduced. May I read, my lord? In the removal of licensing requirement, after clause 6, the following clause shall be added. Except clause 5 and 6, the provisions of the orders may not apply to. Your lordship will kindly see, this is very important. Clause 5 and 6 will operate. Pulse, paddy, rice for a period up to 30th September 2011. Now thereafter, if your lordship kindly continue, then page 23, in 27th of September 2011, it was extended to 31st of October 2011. I'm sorry, 30th of September 2012.
Is the seizure connected to your the criminal proceeding? No.
No, yes. Because ultimately, my lord, they gave me a proposed notice and all that. We have replied to it, but
No, the issue here, we cannot say that it has become non-existent. Issue is still there. But at the same time, your petition under 482 is also there, which will go into the very initiation of the proceedings. You are for quashing. Now, we can balance the equities by directing that this amount which is in the treasury can be refunded to you subject to the final outcome of the 482 petition.
Yes.
That is, I think
can be- that can be,
because
that will take
this,
care of.
this matter is of 2012, I think, or
No, no.
17,
17, 16.
16. We cannot keep this pending.
No,
Should not.
dispose of, my lord. My lord,
Madam, what do you say? Without expressing anything on the merits of the.
Nothing,
Hmm.
but there is a remedy available by that because the 2002 order was not applicable as per the 2015 notification pulses. Well, he could have filed an appeal under the articles order.
No, appeal when? Appeal period is long over.
Yeah, that was over.
That was
30
over.
days is the time period.
My contention will be little different, my lord, though my lord lordship is saying that not going to merit. My contention will be that let us assume that pulse was not exempted from 2002 order. Even then, my lord, to make any restriction with regard to or to regulate the my lord movement and sale and other things of
No,
the
you said you are relying upon two judgments of this court, wherein 82 order has been promulgated without taking the concurrence of the central government. Where
Yes.
is the observation?
my lord,
But the virus of 82 is not under challenge.
Under challenge.
Virus of 82 is not under challenge that because of
no,
incompetency.
virus of 82 is not there.
Then-
But in those two cases, my lord, the question asked for consideration that until and unless you take the my lord, consent of the central government to promulgate the order in respect of the items which is listed in the my lord, that
Schedule.
GSR 800 of 1978, my lord, that cannot be enforced. And they having not taken the my lord, the prior approval of the central government, my lord, it cannot be. In Numal Chandra Borua and others, people reject it. It will. No, it is. This case, this particular order was the subject matter. You know, in Premier Roller Flour Mill, in Premier that 2013 1 JLR 927, well, the issue was not directly connected with the the 2002 order. So para 11 will be relevant.
Madam, the 80, this Premier Roller Flour Mill
Yes.
has touched upon has held declared 82 to be ultra virus.
Yes.
So for 2000, the articles which are covered by 2002 order, and pulse is not covered by 2002 order. So there will be in certain time. The lordship will para 12 also.
Yes, the division bench judge touched on that.
Paragraph 2012 of this decision is en masse holding the 82 order as ultra virus. So if that goes, and the action was taken under the 82 orders only.
Yes. That was my basic contention, I'm not saying that pulse was not exempted at that point of time, but once pulse is included in 2003, by amendment in the 2002 order, it goes away from there. Then if any regulation that has to be made by the state government, 82 order will not cover.
No, if this Premier Roller was decided in 2012, would action be taken under the 82 Act thereafter?
It having not been challenged. Yes.
82 Act is not, is not an existing law in view of this.
As per this judge.
No, it says in respect of the articles which are covered by 2002 order.
No, the 12 is a very general observation.
Yes.
In the result and the reasons discussed above, the writ petition succeeds, hereby declared that the Assam Trade Articles
Stock
Licensing
movement
and Control Order 1982 is ultra virus
Yes.
the so-and-so Act of 2002 read with so-and-so?
Yes.
So far as relates to the commodities covered by 2002 order, read with 2003 order.
My house was included in 2003 amendment.
But where the subsequent notification regarding exemption for 6 months, where those notifications taken into consideration? Here, in this
Yes.
case, Premier,
The premier, my lord, those, my lord, those,
Madam, that option is, I think, still available. Release the amount, make it subject to the
Outcome of the
outcome
criminal
of the
proceeding.
criminal petition. Let us finish this off. Otherwise, it will be an unending matter.
Well, look, the seizure, of course, was made under section 6A to subsection I of the,
Essential commodities.
yes. The seizure, the order under challenge, well, page 56 of the, it was made under section 6, capital
that
A.
was disposal of the my lord, right? That was made.
That was the
Page-
That under section, under
Page,
the,
madam.
page, my lord, 56 of your lordship brief, my lord, the first brief petition. my lord. That is the order under challenge. That was made under section.
6A2, essential commodities.
given to the,
Section 6, capital A.
Of the EC Act.
Yes.
no confusion.
And you will be right in contending under 6C, appeal is provided. Any person aggrieved by an order of confiscation under 6A
Yeah.
within 1 month from the date of communication to him of such order appeal
Yeah.
to any judicial authority appointed by the state government concerned.
That remedy was there, available. That was not resorted by the,
Will not have the time to even to dictate. Well,
No confiscation order was passed. It was sold off, money was deposited in the state.
okay. We'll pass orders later. Heard Sri K. Agarwala, Learned Senior Counsel, assisted by Sri A.K. Sahawala. Full stop. For the petitioner, also heard Miss S. Sharma, Learned State Counsel,
all the,
appearing for all the respondents. The hearing is concluded. The judgment is reserved.
In the other decision which I have given, my lord, it was not directly in respect of 2002 order, but it was held to be, my lord, ultra virus because you say that no.
That is for the order of 82, the other one.
Other one also.
Articles order.
Yes, correctly.
Nomal Borua,
Normal order.
public distribution articles.
There was another decision of the apex court, where also, my lord, the amendments were made. some notifications were issued without, my lord, taking the prior consent of this, my lord, central government. In, my lord, district collector, 1989, 2 SCC 58. Say that once you don't take the prior approval of the central government, those cannot be enforced. No, I can just give a copy, please.
Now that this has been referred here. The
That is
Chit-
referred,
Chit-
that is already.
Chittur case.
That
That has been referred.
is referred.
We'll take that.
I have a copy to that. My lord, if the seizure itself is bad, my lord, everything goes.
Okay, we'll consider. Mr. Dr. Saraf,
Remedy,
yes, anything, madam?
nothing but
Oh.
the remedy, my suppose, see whatever the lordship decides, but the remedy was available to the petitioner, that was not exhausted.
Item 15 and 16.
Those competition matters. There has been mentioned that there's an interim order and there's an urgency, but somehow we're not being able to catch up.
Are going on, so,
Hmm.
so lordship will fix up.
Yes, Mr. Das?
Any short date, your that's the only request.
You know, they, your lordship can come in 28 because I.
No, in spite of having the best intention to have the matter somehow,
Well, because the other matters are there.
all matters are there. somehow.
Top of the list matters were there.
Your Honor may consider 28, Your Honor.
2-8,
So 21st, I could have done it, but you know, there are two series are there in.
then
total one.
28, 2-8.
28.
Mr. Mahanta will be there?
He'll-
Okay, 28, huh? Item numbers?
15 and
16.
15, 6, paucity of time, huh? 28. Interim order passed earlier to continue till the next date of listing.
But in the meantime, if your lordship is liberty, I may prepare a short note also for that,
Yes, please do.
so that
Um,
will
May-
it may
yes.
come.
Mr. Roy Chaudhary, we kept you waiting.
I'm waiting whether this is for teacher.
Same case.
Same. If lordship may give a date, my lordship, only question is whether the review order passed by the registered cooperative society.
Correct.
Correct.
That will not take much time. We thought that this matter would be over.
To produce the record, my lord, till date, my lord, they have not produced that.
Who, government?
Cooperative society.
My lord, the record was also, but for the instruction.
Get the records, we'll fix a date, try to get the records.
The early date, maybe it can be fixed.
Matter of which year?
22, my lord, but it is a cooperative society, my lord, holding election after the application is that and that has been upheld by the
Why are the records required?
record, because on the record, it is clear that the review order was passed on the record. Record, there is a manipulation of the AGM.
Okay, you try to get the records. Yes, but it will have paucity of time. Did not allow the matter to be taken up today. Para. As requested, list on
Early date may be given 28 or 2.
28. 28, we have already fixed this matter. Don't keep it on. Have it on 4th of April,
4th of April.
4th of April, that many
Thursday.
matters are there.
we're hearing the
Can it be on 2nd, my lord?
second of the fixed matters. We can have it on 2nd, we can try, but I think 4th would be better. Okay, 2nd April.
Interim order to come.
Learned, the Learned Council appearing for the Cooperation Department is to produce the records. Full stop, para. Interim order passed earlier to continue till the next date of listing.
6th on 2nd.
2nd. Madam,
It will come for admission hearing.
today it was for what? For admission hearing.
But I'm taking your indulgence in respect of item number 10.
Yes.
Lordship, there's some urgency in the matter because the petitioner before Lordship is a person with disability. And he had made the claim under the PMAYG scheme, which is the Awas Yojana scheme. Lordship, they have also filed their affidavit and I have also filed my reply in regard to the same. The only difficulty is that the entire scheme itself lapses on 31st of March 2024. Hence, Lordship, the urgency in the matter. If I could perhaps pray before Lordships any date next week, Monday, Tuesday, Wednesday.
But it's a matter of 2024.
Lordship, it is, but then, like I said, this is a man who initially he had made the representation in 2018.
No, it is okay, but special preference, okay, but he comes to the court in 2024 and expects his matter to be
Lordship,
taken up before
he's
March.
90% visual impaired. That is his disability, Lordship. And hence not aware of
When did the
entire-
cause of action arise?
Lordship, he had first, of course, applied in 2018. They have not considered his claim. They have kept the 5% reservation quota as per the scheme. That is the entire challenge in the writ petition, Your Lordship. That they have kept him in the regular
We
list of.
can't give a date of 2024.
Lordship, today it was fixed for consideration today, Your Lordship. If I may only pray that a date may be fixed next week, any day as per Your Lordship.
Next day, we have got all matters for the next week.
Lordship, I can only pray before Your Lordship.
12 and 14, both dates, all pending matters of 12, 13, 14.
I'll take a chance, Your Lordship.
24 matter, Madam.
Wednesday, Your Lordship, even if it was on a Wednesday, today was fixed for consideration, was item number 10 for paucity of time, it couldn't be taken up. Your
Let us see with the file, what was the order? So, I didn't tell.
Lordship. What-
There is no indication.
Lordship, on the first date itself, Your Lordship, 10/1/2024, if Your Lordship will see.
10-1.
10/1/24. On the next day itself, they were required to get instruction. Then thereafter, the council could not come on a particular date. Then they took time to file their affidavit, Your Lordship. 2 weeks was given, they took 4 weeks to file it. I have immediately filed my reply to the affidavit, Your Lordship. And I've even called for the
There
affidavit.
is an
today.
interim order.
No, there's no interim order, Your Lordship. My entire claim is for the entire consideration. Whether I am entitled to
No,
the
why,
claim or not.
there's an observation that interim order would continue?
No. Okay. Lordship, start looking at item number 10.
7/3 to 20, yes, your submission. 7/3/2024. Interim order passed earlier shall continue till the next returnable date.
There's some Lordship, I apologize.
What is the urgency?
Lordship, actually, the petitioner before your Lordship is a person with disability.
No, that is not an
And
urgency.
also, Lordship, he's also a below poverty line person. Now, as per the scheme of the government of India, there are certain beneficiaries who are entitled to get a 5% reservation in these schemes as per the Rights of Persons with Disabilities Act 2016.
Okay.
Now, he had applied for this particular scheme in the year 2018. Having applied there, he's been running from pillar to post, and for some reason, his name is not being considered under the relevant category. Now, they have come up with an affidavit a few days back saying that he is till serial number 39 of that list.
Okay.
The beneficiaries have already been given the whatever amount of money is required to be given under the Awas Yojana, and his name now stands at serial number 2, which is basically he's at serial number 41 of the list as per their contention in their affidavit, Your Lordship. Now, the problem, Your Lordship, is that the entire scheme itself lapses on 31/3/2024. This is an illiterate, destitute man, Your Lordship. He has no idea of the entire, how it is working or what is happening. He's a homeless man. He's asking for some funds under the Awas Yojana to be able to build a home for himself. And the respondents are not denying his claim. Only the urgency remains that, Your Lordship, I should have been given a preferential treatment, which is the mandate of the law, which is their own
Madam,
mandate.
we have come to the court very late.
Lordship, I completely.
There you don't have an explanation there. You are
No,
canvassing your advantage which you should be given. Why don't you come to the court in time?
Lordship,
When did
problem
you
is
file
that
this
these-
petition? You filed in January and you're asking for a disposal in March. Is it possible? All matters are important.
Naturally,
All matters are important.
My
House
only,
for thousand lakhs of people are there waiting for their houses.
Lordship, my only concern was that the entire scheme lapses.
We are not
If I'm
impressed.
Lordship, may kindly give me one chance, Your Lordship, just one date. If I'll
We
take my
tried to see
chances.
whether there is anything, nothing.
Lordships will see their own scheme.
Paucity of time did not allow the matter to be taken up today. Full stop. MS R.S. Chaudhary, learned counsel for the petitioner, submits that the reply affidavit has been filed and there is urgency in this matter. Full stop para. List on 27th of March, 2024 for admission.
Obliged.
You could notice.
Okay, please.
আপনি সব প্রপোজাল আছে এটাতে গুড আপনার হাইওয়ার্সে মুখ কি জ্বলে যে আপনি আজি টিফিন খাব কি এনে শান্তি মতে ভাই
That's what I'm